of the impugned provisions and the appointments made there under lordship. That the impugned provisions are ultra vires, Article 14 and 324, as interpreted by the Constitution Bench in the case of Anup Barnwal. And they failed to, lordship. The important point is that they failed to take care of the serious lacuna which was fully accepted and shared by Dr. Ambedkar in his reply to debate on Article 324, lordship, which I have reproduced in para 17, lordship, of my writ petition at page 11. Kindly permit me to read just one sentence, opening sentence of that para 17 at page 11, lordship. That replying to the debate of Dr. Ambedkar had said, and I quote, "There is a great deal of force in what my friend Professor Saxena said, that there is no use making the tenure of the election commissioner a fixed and secure tenure if there is no provision in the Constitution to prevent a person who is likely to be under the thumb of the executive lordship." This serious lacuna was accepted by Dr. Ambedkar, but the new act also, it fails to take care of this lacuna, lordship, apart from violation of Article 14, lordship, which I shall come to later, lordship. Then, lordship, consequently, the impugned provisions
Please continue, sir.
Dear lordship, consequently, these impugned provisions, they give a free hand to the executive of the day to misuse the power of office, as has been, they have misused the power given by the act to them. Confirming the observations in para 204 of the lead judgment in the case of NJAC, NJAC case, wherein it was said that, and kindly permit me to just read two sentences from that para 204 of the lead judgment in the NJAC case, lordship, wherein it was said, what emerges, I'm quoting from para 2, just two sentences to save the time of the Honorable Court. What emerges is trappings of the spoil system and nothing else. This is what the court had observed then, lordship, which is happening, coming to be true even every successive day. Lordship, that was the first sentence. The other sentence in this very para, the lordship observed was, demonstratively, that is exactly what has happened repeatedly in the matter of non-judicial appointments like this, like the present one. So what the Honorable Court had observed in the case of NJC is being repeated in this case also, has been repeated, lordship. Then, lordship, now, yes, lordship. Now I'll come to the impugned provisions, lordship, as to why they are untenable. Lordship has brought out in paras 45 and 46 of my writ petition as page 27 and 28. 27 and 28. Approval of the cabinet and the parliament on the 2023 bill was obtained by concealing the relevant material, like the report of the National Commission to review the working of the Constitution, and the report of the Law Commission. Those were not brought to the notice of the cabinet and while approving the while approving the bill for presentation in the parliament, nor were they brought to the notice of the parliament. And their approval was obtained by concealing these reports, and it was given without application to these reports, Lordship. That is my point, and
Sir, where is the
that's
cabinet?
why that approval was vitiated, Lordship, both of the cabinet as well as the.
Is the cabinet note on record?
Yes, Lordship.
Is the
Yes.
cabinet note on record?
Yes, Lordship. I have filed a copy of that. Yes, Lordship. I have annexed it with my petition. I obtained it
Where
under
is
the
it in your
RTI Act,
petition?
Lordship.
Which page?
The cabinet note which was put up to the
Where
cabinet.
is it in your petition?
Lordship, 1 minute. It is in the petition, Lordship. It is there. It has been filed in the petition. Lordship, 1 minute. Note for the cabinet, that is at page 96, Lordship. I obtained it under the RTI Act, Lordship. From page 96 onwards, it is the cabinet note. It is totally silent about these two reports, Lordship.
दिखाइए.
Yes, Lordship. So that was my first point, that the approval on the bill was obtained by concealing these reports from the cabinet as well as from the parliament. Then second point, Lordship, is, if I can, yes. The second point is that the statement of objects and reasons, Lordship,
Give it,
which
madam.
is at page 104 of my statement of objects and reasons of the bill for this 2023 Act, that is on page 104 of my writ petition, Lordship. Annexure, it is annexure P8 at 104.
Yes.
Yes. Lordship will be surprised to see that this SOR did not even mention the grave legitimate concern of the framers of the Constitution about the imperative of the apex court to intervene, leave alone indicate as to how the bill took care of it, Lordship. They didn't bother to address this issue in their statement of objects and reasons for coming up with this bill, nor it gave any explanation for changing the selection committee named in the Constitution bench judgment, which was as per recommendation of the Law Commission, Lordship, which was concealed from the cabinet and the parliament. They didn't give any reason for not, they didn't consider even the recommendation of the Law Commission, which was as per the judgment in the Varnamal's case, Lordship. So that is significant. This is the second reason as to why the approval of the parliament was vitiated, Lordship, on the act. Then,
It's also there in the SOR.
yes, Lord. Lordship, then the impugned provisions in section 7 and 8 of the act, which are reproduced at page 23 and 24 of my writ petition, and they are also in appendix B to the writ petition.
Yeah.
Yes, sir.
Yes, Lordship. Uh, these section 6 and 7, Lordship, they do not meet the requirement of the selection process, ensuring the four fundamentals of the election commission: impartiality, fearlessness, transparency, and purity, stipulated by the constitution makers while enacting Article 324, Lordship, and mandated in the judgment of the Constitution Bench, on which, Lordship, this is important, the Minister for Law and Justice had also agreed in his reply to the debate on the bill. He agreed with these four requirements of the Election Commission, but he brought a bill and got it passed which don't meet these requirements, Lordship. This is the difference in what is said and what is done, Lordship. In view of the law laid down by the Constitution Bench in S. Krishnan versus the State of Madras, Lordship, AIR 1951, Supreme Court 301, AIR 1951, Supreme Court 301, and 1951 SCR 621, Lordship. The same citation, same case, different citation.
You are
That
relying on
any
which paragraph,
enactment
sir? Which
passed,
paragraph of this judgment?
sorry,
Which paragraph of this judgment you are relying on?
I've got the page number at 624. This is said. What I'm quoting, the judgment is reported at 621, but the sentence I'm going to quote is at 624, Lordship. The
This is from the
their
SCR?
observation, the Lordship's observation, that any
नहीं नहीं AIR
Yes.
बोला 301.
Yes, sir. 1950. Yes, Lordship. 1951 SCR 621. Sorry. Page 634.
SCR.
Judgment is at 621, and the sentence I'm quoting is at 634, wherein it was held that any enactment passed with the purpose of defeating constitutional provisions, like in this case Article 14 and 324, can be assailed on the ground of being a fraud on the Constitution. So this act also, Lordship, is nothing but a fraud on the Constitution, in which, in view of the reasons which I have mentioned and I am going to mention further. So this is the submission as regards section 6 and 7 for both. Now I'll deal with these sections separately, Lordship. That is the general point applicable to both the sections, Lordship. Then section 6 relating to search committee is liable to be struck down for the three reasons which I have mentioned at page 2 of my written submission. Lordship, I had filed my written submissions in this matter, which were circulated with the office report dated 5th of May, Lordship. That is important. These written submissions are already on record, Lordship. They were circulated with the office report dated 5th of May this year, Lordship. So I'm only referring to the submissions in those written submissions, based, of course, on the pleadings. So, Lordship, the search committee is liable to be struck down.
Yes.
Yes, Lordship. The first reason as to why Section 6 needs to be struck down is that the amendment to Clause 6, Lordship, to the bill was moved by the minister without the requisite approval of the cabinet under Rule 4.1 of the Government of India Transaction of Business Rules 1961 and was got passed by the Parliament, concealing this fact, hence cannot be sustained for this reason, Lordship. This amendment was not got approved by the cabinet because for the reasons which I have mentioned in para 49, Lordship, of my petition at page 30, Lordship. It was moved without the requisite approval of the cabinet under Rule 4.1 of the Government of India Transaction of Business Rules, Lordship. And any decision taken in violation of the rules, of course, Lordship, cannot be sustained. Then secondly, the secondary, sorry. Lordship, this I have stated in para 52 of my petition. This reason is in para 52 of my writ petition at page 3132. Page 3132, para 52. This reason I have given in detail, Lordship.
Yes.
In the writ petition. Then, Lordship, the second reason is that significantly, even while moving the official amendment for replacing Clause 6 by the present Section 6, the Section 6 makes the minister chairman of the search committee, Lordship. In the original bill, it was the cabinet secretary, as usual. Cabinet secretary is generally the chairman of the search committees in all the search committees, Lordship, for various constitutional and administrative posts, high posts. It has been the cabinet secretary. Here, the original bill also, Lordship, provided for the cabinet secretary, but it was moved, and this amendment was moved at the time of the debate on the bill, Lordship, by the minister at the last minute. So even while moving this official amendment for replacing this Clause 6, which provided for cabinet secretary by the minister, no explanation was given to justify the change regarding the committee being headed by the minister instead of the cabinet secretary, and for dropping the words having experience and in matters relating to elections. So this change was made surreptitiously at the time of moving the bill. Nor were these changes discussed during the debate, Lordship. This is important because I have gone through the debate on the bill, and this change was not discussed at all, Lordship. I have mentioned all these things which I am submitting, Lordship, in my written submissions.
Yes, yes. Yes. 51 is.
S. Krishnan, which paragraph are you relying on?
Lordship, for this, this is there in para 53, Lordship, of my writ petition.
No.
This is,
The-
I'm referring to
The
that.
particular passage from S. Krishnan
this,
you read out
but
is
yes,
from
Lordship.
which paragraph? 51 Supreme Court. Which paragraph?
Yeah.
or SCC?
53, Lordship, at page 32. 53, para 53, page 32, Lordship. The submission is there, Lordship, from that
No,
paragraph.
but how does the paragraph start? What is the starting words?
1 minute. 1 minute, Lordship, I'll just... Lordship, may kindly have my amended petition, because the original petition was subsequently amended twice, and this I'm referring to the amended petition, Lordship. These para I'm mentioning of the amended petition. 52, I'll just read, Lordship. It starts with this. 1 minute. Yes, Lordship. This is at page 31. That a perusal of the aforesaid note dated 6/12/23 in file number such and such, received with the letter dated such and such of the legislative department refers to the herein before, shows that the approval of the cabinet for the change in the composition of the such committee proposed in the original bill was introduced in August 23 was obtained without sorry. That was regarding the first point, Lordship.
Regarding the
Para
first point,
52.
sir, which paragraph of
At page
S.
31.
Krishnan are you relying on? Can you give us the paragraph number and the starting words?
Lordship, Lordship. For the first point, Lordship, para 52 of the amended writ petition, Lordship, at page 31, Lordship.
From the judgment in S. Krishnan, AIR 51, which paragraph of the judgment?
No, the AIR 51, because I don't have the para number of the AIR.
Sir, SCR does
but
not have
in the
paragraph numbers. SCR does not have paragraph numbers. So please tell
exactly,
us,
Lordship.
how does the paragraph start?
Lordship is right. Lordship is right. For the SCR, I have given the page number. The judgment begins at page
Sir, please try to understand.
621.
Please read
The
out
earlier judgment, Krishnan versus the State of Madras.
Can you read out the paragraph in its entirety from the first
Yes,
word? You said that if any law is enacted to defeat the constitutional provisions, it would amount to a fraud. Where is this particular expression in the judgment? Which particular paragraph?
Lordship, I don't have the para number, but it is at page 634 of the judgment in the SCR.
Sir, do you have a copy of judgment before you? Sir, do you have a copy of
34.
judgment before you?
No, Lordship, I don't have copy of that. I got this.
No.
I got this sentence while going through the judgment in the net. While going through the judgment in the net, I got this copy. I mean, this particular sentence, which I thought is applicable to our case. I am giving the page number of the SCR, Lordship, where this sentence is there, 634, Lordship. The judgment is at page 621, and this observation is at page 634, Lordship. Page number I have got, not the paragraph number, because it is not there.
Let's say
34.
Page 634, Lordship.
1 second.
It was held in that case, Lordship.
But sir, this is saying it was frankly conceded that if Parliament or a state legislature passed legislation in a manner which amounted to a fraud on the Constitution, inasmuch as those enactments were passed with the purpose of defeating the constitutional provisions, then those laws could be attacked on that ground, but not on the ground of their vires. That in the present case, no such argument had been taken or could be taken. And that being so, the contention of Mr. Nambiar was not justified.
Can I give the para number?
There is no paragraph.
No, in SCC, it is reported, it starts in para 34, in SCC, my lord.
That will be an
Already has it.
I'm saying,
Look, there are judgments given by 4 learned judges.
yes, my lord.
So
What
the
my-
lead judgment is by Justice Patanjali Shastri,
Please, your lord.
right? The portion on which Mr. Shukla is relying is by Justice Mahajan,
Yes. Concurring judgment.
concurring view.
And it starts with saying, after a careful consideration of the argument by Mr. Nambiar, I have reached to the conclusion. My lords have got it.
Yes, yes.
If your lordship have SCC, my lord, I
And
can.
we are on that paragraph 34, SCC.
Please.
Yes. But is it law declared? That is what is to be found out. Very strong words, no doubt.
It can be assailed.
Whether it is law declared, that has to be shown.
It,
Very well. Continue, Mr. Shukla.
Lordship, it was said that it can be assailed. Yes, Lordship. Yes. Yes.
Yes,
Can I
yes, sir,
continue,
proceed.
Lordship?
Please proceed.
Sir, please
Yeah.
continue.
Grateful, Lordship. That was earlier, Lordship. Then I was on this section 6 being liable to be struck down. The first reason I had mentioned that it was moved by the minister without the requisite approval of the cabinet.
Right.
That is in
Yeah,
para
okay.
52 of my writ petition, Lordship. Then I was on the second point that it didn't give any explanation for to justify the change in the committee had to be headed by the minister instead of the cabinet secretary as proposed in the original bill. Lordship, this point is in para 53 of my writ petition at page 32, Lordship. Evidently, the approval of on this point, I am quoting this, evidently the approval of the House on the said amendment was obtained and given without any application of mind, contrary to the law laid down in ONGC Limited versus Western Geco International Limited, 2014, 9 SCC 263, para 38. This I have mentioned in para 53 at page 32 of my writ petition. This is the second reason as to why section 6 cannot be sustained.
Yes.
Then, Lordship, the third reason is it is also violative of Article 14, being vague, irrational, and arbitrary for the reasons detailed in paras 54 and 55 of the writ petition. I'm summarizing: by making the minister chairman of the search committee, its political neutrality and fairness has been clearly compromised, and the whole process of having the committee to identify the ablest, bold, and independent persons got. And one point which is not here, Lordship, which I have somehow got omitted in this written arguments, is that it is important, Lordship, that this is not a committee. This is not there in my submissions, but I'll just add it here just to clarify. Lordship, it is not, such committee is not a committee, Lordship, because the other two members of the committee are nominated by the minister himself. So it is a one-man show, Lordship. That is a very important point. It is committee only in name. Under the rules of business, all orders in matters which don't require to be referred to the Prime Minister or cabinet subcommittee, the minister is the final authority. So in this case also, the minister can nominate the other two members of his choice. And that is what has been done in this case. The other two members were nominated by the minister. So virtually, it is a one-man committee, not the search committee. In all other cases, Lordship, in all other for all other offices, the search committee generally consists of the cabinet secretary, the secretary department of personnel, who handles the senior officers matters, and the secretary of the department concerned. So here also we have proposed that the search committee should be the cabinet secretary, secretary of the department of legislative department, which is the concerned department, and the other member, the secretary of the department of personnel, because he would know the biodata of the eligible officers.
Yes.
So that should be the. So it is not committee at all. It is just one-man show, Lordship. That point somehow got omitted here, but it is there in the writ petition, Lordship.
Very well.
Thanks, Lordship. Then, Lordship, I'll now come to section 7.1 relating to the section 7.1. This is this was regarding section 6 relating to subcommittee. Then I come to section 7.1 relating to the selection committee, Lordship, as to why it cannot be sustained. Likewise, the composition of selection committee in section 7.1 is also violative of Article 14 for the following reasons detailed in para 59 of the
Right.
petition. These reasons I have detailed in para 59 at page 37 of my writ petition. And now I'll just briefly summarize these reasons. The first is mere inclusion of the leader of opposition is meaningless, as his opinion can be ignored and overruled by the Prime Minister and the Minister, as has been done in this case, defeating the whole purpose of having a selection committee. So here again, it's a one-man show. It's not, it's committee in name only. The decision maker is the Prime Minister. That is the first thing. Then the second point, Lordship, is the present composition by a 9 judges bench in the second judge's case and reiterated by 9 judges and another 9 judges bench in the special reference wherein it was held, Lordship, and I have quoted from that judgment, wherein both the 9 judges benches, Lordship, they said this, and I quote, attention has to be focused on the purpose. What is the purpose of the committee? The purpose of the committee is to get a person who is acceptable to all political parties or to most political parties, not only to the ruling party, Lordship. Attention has to be focused on purpose. That purpose is missing here, Lordship. It doesn't pay attention to the purpose of the committee, the selection committee which has been provided in the Act. Then to enable better appreciation of significance of the role of each participant. Each participant of the selection committee has a role, and that role has to be appreciated. The present composition does not appreciate that role. I mean, doesn't leave any scope for appreciating the opinion of the leader of opposition, Lordship, because the other two can combine and take a decision and ignore his opinion. So that the role of the third person is zero in this case, Lordship.
Yes.
With the consciousness that each of them has some inherent limitation. That limitation is already inherent in PM and the minister being on the one side. So naturally, that limitation is that they would like to have a man of their choice rather than listen to the third member of the committee. So all these, and it is only collectively that they constitute the selector. That is the 9 judges bench, Lordship, that they collectively constitute the selector. So to say that the 2 members of the selection committee are good enough, they can take whatever decision they want. This sort of decision making is totally against the 9 judges, 2 judgments of the 9 judges bench's, Lordship. That is our second point, Lordship. Then, Lordship, the third point is that it does not remove the grave lacuna in the procedure for appointment of CEC and ECs, for the removal of which the Constitution Bench had intervened, defeating the whole purpose of the well-considered decision. That is another point, Lordship.
Right.
In this respect, Lordship, paras 160.
We will look into it. We will look into it. Come to your point 4.
Or they have already been brought to your Lordship's kind notice. In point 3
Point
is,
four,
Lordship,
point
this is in para 62, which I just mentioned. Point 4, yes, Lordship. Point 4 is, as brought out in paras, 1 minute, Lordship, I have difficulty in reading. As brought out in paras 84 at page, para 84 at page 57, of the writ petition, the selection committee, as it is constituted, has an inherent incapacity to select the best person through an objective assessment. The composition of the selection committee has an inherent incapacity to select the best person on an objective basis, Lordship, for the simple reason that the other 2 members can overrule the third person. So there is no objectivity in the selection. So for these 4 reasons, Lordship, our submission is
you
that
have referred
section
to Justice
7.1
Nagaratna.
cannot be sustained.
Is there a judgment? Please see written submissions, paragraph, page 3, foot.
Yes, Lordship. Page 3. Yes, Lordship. I'm on page 3 only, Lordship. I have not mentioned the judgment, Lordship, but this point was made in one of the articles. Para page 57, 84.
Yeah.
Please continue, Mr. Shukla.
Yes, Lordship. This fourth point, Lordship, I have mentioned in para 84 at page 57 of my writ petition, and it was taken from an article by Mr. PDT Achari, former Secretary General of Lok Sabha, in the Hindu dated 28th of February 25, wherein he had made this point that thus the selection committee as it is constituted has an inherent incapacity to select the best person through an objective assessment. This is what he said, Lord.
Very well.
So this
And what
point I
about
have
the
taken
next
from that.
paragraph? What about the next paragraph in your written submission?
Give-
Next paragraph,
Yes,
just
Lordship.
immediately after that.
Yes, Lordship. I'm coming to that, Lordship. So for these four reasons, Lordship, the selection committee cannot be sustained in view of the position stated above. Now I come to the next paragraph, Lordship. In view of the position stated above, in its present form, Section 7(1) of the Act cannot be allowed to stand as it does not ensure an independent election commission. Hence, Lordship, we have suggested rather, it needs to be read down with the proviso that in case of lack of unanimity among members of the selection committee, the matter shall be referred to the Honorable Chief Justice of India,
This is
whose
your
decision shall
submission.
be final, Lordship. This is the
whole
only way
part-
to ensure, yes,
This whole
Lordship,
part
that
is your submission.
so that their Lordship compelled. Ji, Lordship. This is our submission.
have you
This
referred
is
to
our
Justice
prayer also,
Nagaratna?
Lordship. in
Why
the
have you referred
petition.
to Justice
And that is
Nagaratna?
the only way to.
Speech, apparently.
Recently, she made similar observation, Lordship. I read it in the live law. So that is what I have.
No, no,
That's why I
you're making
included
a
her
legal
name also.
submission
Lordship,
before a
in this.
court of
With
law.
the same thing she said.
You should not be so casual, Mr. Shukla.
No,
Anything
that
and
was.
everything said in course of an address. We need to give weight
Yes.
to what our planet sister says, but you must indicate the source that this is not part of a judgment. We would be misled.
No, it is not part of the judgment. But this supports our submission, Lordship, that the only way to save this impugned provision is
Very well.
to
very
read
well.
it down
Come to
with
your
this
next point.
proviso.
Section 8. Why is Section
Ji, Lord.
8 ultra-virus?
Section 7(2) also, Lordship, for the reasons stated above, the totally unnecessary and undesirable provision in Section 7(2) of the Act also
Very good.
needs to be struck down.
Come to 8.
Then, sorry, sir. Yes, Lordship. Then the impugned provisions, one more submission, Lordship, that the impugned provisions in Section 6 and 7 of the 2023 Act are also against the object and purpose of Article 324(2) of the Constitution as interpreted in the observations in paras 164, 165 and 186 of the judgment of the Constitution Bench in writ petition number 104, 2015, Mr. Banarmal's case, reproduced in para 62 of the writ petition, Lordship. Then, Lordship, in view of the position stated above, our submission is that Section 6 and 7 of the Act are liable to be struck down in terms of the law laid down by the Honorable Court in Akhil Bharatiya Upbhokta Congress. I've given the citation, para 50, and in Maneka Gandhi versus Union of India, the citation I have mentioned in the written submissions also. Plus, I have also added yeah, some other rulings of the Honorable Court from the SCR, Lordship. So for the law laid down in these cases, these provisions are violative of Article 14 and they cannot be sustained, Lordship. Then, Lordship, Page 46.
The reading is not there.
Lordship,
Any
my
further
next point is
submissions?
that, Lordship, yes. The next point is that the provision in section 8 uh, uh, of the Act without any norm or guidelines in this regard is also not in accordance with the observations in 2023-4 SCR 284 para 6.5 cited in para 64 of the writ petition. Hence, this provision needs to be supplemented as per prayer 642 in the petition. Lordship, in para 64 of the writ petition at page 46, Lordship, I have said that that the provision in section 8 of the writ petition is not in accordance with the following observation of the case just I cited in para 6.5 of that judgment, and I quote, Lordship, even otherwise also we are of the opinion that Rule 6.9 lacks transparency and it confers uncontrolled discretion and excessive power to the selection committee. Under Rule 6.9, the selection committee is empowered with the uncontrolled discretionary power to determine the procedure for recommending candidates, to recommend candidates to be appointed as president and members of the state and district council commissioners. Now, the same thing is here, Lordship. It only says that the selection committee, what procedure they will follow is not indicated, no guidelines are given. So for the same reason as given in this judgment, Lordship, the section 8 cannot be sustained, Lordship. Then, Lordship, I just read the judgment in para 64, cited in para 64 of the writ petition at page 46, Lordship.
Very well. We'll look into this judgment. Mahindra Bhaskar Limai.
I come to the Lordship. Now I come to the second part of our petition, that is challenge to the appointment of the present CEC and both the ECs, Lordship.
Right.
Apart from the constitutional invalidity of sections 6 to 8 of the Act, the appointments of respondents number 3 to 5 as CEC and ECs cannot be sustained even under the impugned provisions for the following reasons. We have given 10 reasons, Lordship, as to why these appointments cannot be sustained, Lordship.
Right.
The first one is that they don't fulfill even the basic requirement of knowledge and experience in the management and conduct of the elections as stipulated in Section 5 of the Act. Section 5 of the Act provides that they have to have this basic requirement of qualification,
Basic requirements.
knowledge, and experience in the management.
Sir, they are
Section
having this
5,
basic requirement.
Lordship.
They are all the.
This is suppose.
They are having this basic requirement.
No, Lordship. Yes,
Because I was going through the petition.
this is required, Lordship. Now, this,
Please wait. One of them is ex-chief secretary.
yes,
They are all IAS officers. And you are also an ex-IAS
no,
officer.
Lordship,
And all IAS officers,
that
during
is not
their
enough.
service career, they function as
Yes,
returning
Lord.
officers. They function as observers. So they do have experience in management and conduct of elections.
No, in the,
A chief secretary must have
I'm
number of
referring
times as returning
their-
officer. So they do have the experience, sir.
your Lordship is
Even
right.
you must have
Your
also worked
Lordship
as
is
returning
right,
officer.
but Lordship may kindly.
Where it is defined that what does it mean?
No, Lordship, I didn't.
See, you have also worked as returning officer.
Lordship, just a minute. I get your Lordship's point, but Lordship may kindly have the biodata of the Chief Election Commissioner and the other election commissioner at page 107 and 108 of the writ petition, which I have downloaded from the website of the Election Commission. It does not have a word about their knowledge and experience in election. So one wonders as to how they could be considered good enough for this job. Lordship may kindly have just 1 minute at page 107 and 108. Not a word about the basic requirement which they had to fulfill.
Sir, you are also an ex-IAS officer? Your answer is yes. This man is an IAS officer.
Yes, I was.
He has worked as collector. He has worked as a commissioner. So he must have worked in large number of elections as returning officer. He must have gone to other states as observer.
But
So please don't, these are all frivolous grounds.
then all this should have come in his
The chief
biodata
secretary has
on
never
the site
worked as
of
a
the
returning officer.
Election Commission. Lordship, 1 minute, Lordship. He himself must have
That's
given this
okay.
biodata.
No, you
approved
tell
this
me whether you
biodata.
have worked as a
It
returning
doesn't
officer
mention
or
that.
not
All that
during
I'm
your
submitting.
service career.
No, I'll come to that also.
No, leave this
Lordship,
point.
I'll
If
also
an
come
IAS
to that,
officer is
that
there,
the
he must
selection
have
committee and the
conducted
search
hundreds of
committee
elections.
did not consider this issue.
This is all. This is not. Come to your next point, sir.
No, Lordship, no,
You mean to
1
say
minute,
that
Lordship.
chief
The
secretary
search
was
committee
a-
and selection committee did not consider this. Oh, abhi main aunga. I'll show that later, Lordship. Then secondly is not only this, that they didn't have the requisite, qualification and experience in the management and conduct of elections as CEO or as in the chief electoral officer in the state.
The
It
qualification
doesn't say
does not
mere
provide
returning
you to
officer is not
CEO.
good enough.
No, the qualification doesn't state that he has to be chief election commissioner in a state.
No, high level Lordship,
No,
not returning officer.
it's not required. It's not required.
And then second,
So this ground goes.
Lordship, yes, I'm come to the second point. More important is on the next page, Lordship, page 108. This shows that they were picked up for political considerations. This clearly shows, not on their merit, not on the basis of their experience and knowledge in election conduct and management of election. This news report in the Times of India dated 15th of March 2024, says that Sukhbir Singh Sandhu, retired as Uttarakhand Chief Secretary, laid ground for UCC bill in the state, Lordship. This is his qualification. He held post of additional secretary in HRD ministry, NHAI chairman, holds MBBS.
You mean to say that he is the person? It
Yeah.
is by the legislative assembly, not
True,
by an
but
IAS officer who was working as chief
He was
secretary.
picked up, Lordship, he was picked up for that
No,
job.
this is all.
He was
no,
picked
this
up
is
for that
simply because
job,
he was chief
which is the
secretary of
agenda.
Uttarakhand. You can
which is the agenda of the ruling
allege
party.
all kind of odd things against him. This is not done.
Our submission is,
No, next, please, next point, please.
no, Lordship, our submission is that he was picked up for this job because of the political considerations.
All right.
Then a Kerala cadre officer from UP retired as Secretary Corporation in January. As MHA Joint Secretary, he handled scrapping of Articles 370.
So he was
Another
again in the
political
parliament
agenda
as
of
the
the
lone
government.
member,
Oversaw
the lone
Ram
member,
Temple.
because of his voting.
Oversaw
Article
Ram
370 was
Temple.
scrapped.
Then I'm coming to
This
the other
what
point.
kind of argument, sir?
All right, Lordship. Then I'll come to that point.
Yeah, please come to some legal points.
No, not on that, Lordship. But our submission,
right.
our submission is, Lordship, they didn't have any special knowledge and experience in conduct of elections.
sir.
As per their own biodata, they were picked up for political considerations as per that report in the Times of India, Lordship. That is. Then the second point is, the third point I would then come to. These two I have already covered. Even the selection process as mandated in Section 8 was not followed as confirmed by the observations in para 3 and 14 of the order dated 22/3/2024 of your lordships in the writ petition, in the lead writ petition number 14/2024, reproduced in para 69 and 70 of the writ petition, Lordship, that the selection process mandated in Section 8 was not followed. We are not saying this, Lordship. Your Lordships made these observations in the lead petition in the present case, writ petition 14 of 2024. So that is the third reason. Then, Lordship, fourth reason is that as brought out in para 21 of the application for placing the additional facts and documents on record, the President's approval on half-baked note for their appointment as respondent number 3 and 4 as election commissioners was obtained, hiding the fact that only definition in section 2I and 271 of the Act and the law laid down by the 9 judges benches, which I just cited, cited in para 59 of the petition, means all the 3 members had recommended their names, and the third member had given a dissent note and attached it with the minutes of the meeting as evident from Annexure 8 to the application for placing the additional facts and documents on record, Lordship. Moreover, the approval was given without application of mind and was not sustainable as per the law laid down in para 27 of the application, as held in AIR such and such, para 39. Writ of quo warranto can be issued where an appointment has been made in has not been made in accordance with the law, as was blatantly done in this case. Now, Lordship may kindly have my application for placing additional facts and documents on record, Lordship. The approval of the President, which I just referred, Lordship, that was obtained, hiding this fact that the third member had given a dissent note. Now, Lordship may kindly have this application for additional facts and documents.
Page 125
and
of
page
your amended
27.
petition is the
Page
note of
27 of the application.
Mr. Shukla, we have read the dissent note at page 125 of your amended writ petition.
Yes, Lordship. That is the dissent note only. I am referring to the minutes of the note submitted to the Honorable President for her approval. And that is at page 27 of my application for placing additional facts and documents on record. That is I 2024. IA number 138504 of 2024. 4, Lordship. Now, Lordship may kindly come to page 27. This is the note which was submitted to the Honorable President for her approval to the appointment of respondent number 2. Now, has your Lordship got this
Yes, we are on 27.
note? Yes, Lordship. Now, Lordship may kindly come to page 28. I mean, all that is the description. It has no relevance to the decision. Page 27, 28 at the bottom, Lordship, para 8. The selection committee meeting chaired by the Prime Minister was held on such and such date. After detailed deliberations, the selection committee, based on the eligibility and experience, there are no details of the experience and eligibility of these two selected officers, Lordship. The selection committee, based on the eligibility and experience, has recommended following names for the appointment of the vacant post of election commissioner in the. Now, this note gives no details of their eligibility and experience. So the president was not aware of their experience and eligibility. The president just acted, if I may say, as a rubber stamp to approve the note, because these details to justify the selections were missing in the note.
Just 1 minute.
Not-
On 14th February 2025, one of you
Sorry,
pointed out that
Yes.
several developments took place.
Yes.
1, 2, 3, 4.
Yes, that was the list of dates I handed it to.
That was the list of dates.
Yes.
Can you just give us an indication of what was the first event, second event, third
Yeah,
event, fourth event?
Yes.
Just give us one more.
The first is not on 1st of February 24, both search committee and selection committee are constituted.
1st of February.
February 2024.
I'm sorry, there's an interim order of your lordships in
Yes,
our
there
proceeding,
I have given the list of dates.
22nd March 2024, where your lordships have narrated the entire
From
sequence.
there I have tabulated it. and-
Just give us the.
Yes, my lord. And on 4th of February, my lord.
No, what happened on 14th February? Because you had argued that
It happened on 14th March, not 14th February, my lord. What happened on 14th March is, yes, my lord.
14th March 24.
Yes, my lord. The selection committee recommendation, the selection committee is search committee recommendation, selection committee recommendation, selection to the president and appointment. Everything on 14th March. If your lordship had that
Yes.
two-page note, my lord.
It is there.
So 14th March, who was recommended?
Let me just clarify one small thing. There was an IA that we had filed, that
Yes, yes.
Mr. Bhushan had filed. That was filed on the 10th of March. It was filed on 10th of March. On 12th of March, it was mentioned before the court. The date of 15th of March was, 14th of March was given. 15th March was given. Meeting was supposed to be held on 15th
Yeah.
March. 15th March is preponed by one day to 14th March.
That was done on 9th.
No, the preponing
Preponement was on 9th March.
was on 9th.
Yes, yes, it is.
9th March.
Ninth.
Preponing was done on 9th March. Well, we don't know. This is what we have been told.
It was
Yes.
done on 9th.
Whatever.
9th March, no? Preponement, as per Mr.
No, I-
Ansaria's
Yes.
list
it is
of
on
dates
9th March,
is
which I
9th
have
of-
taken it from your lordship's order.
It's
of-
from your lordship's order only.
This is
It's from your lordship.
the
your lordship's
meeting just to
have-
avoid hearing on.
This was taken from your lordship's order of 22nd March,
Correct. Check it.
2024.
Do we have
Yes.
the recommendations of the search committee dated 14th March?
Lordship would have.
The
to-
entirety of those files and records are what Mr. Shukla asked for in that application.
Huh. So
That
it was
is
given
what,
back.
so because we don't have it,
You don't have
We-
it, but Mr. Shukla's affidavit
yes.
also does not have this 14th of March deliberations.
Yes.
I'm not finding it. 14th of March.
No, the deliberations will all be with the learned AG and the government.
No, Mr. Shukla on the last occasion said that he has all the papers
Oh,
received through the machinery of the RTI, which he wanted to place before us. Right, but we don't find from his, either from this application
I don't know.
for additional records to be placed.
And Lordship would also verify, my lord, for your Lordships.
That is not there.
Date which 9th of March I have given my list of dates is from your Lordship's order of 22nd March. My request would be, my lord, to satisfy our Lordships factually, Lordship would ask, my lord, the government to produce that notice by which it was preponed from 15 to 14. I do not know, my lord.
The dissent note is of Adhir Ranjan Chaudhary, who was the leader of opposition then. That he has placed apparently on,
Yes.
yeah, he has placed it on Twitter also. But there is what page
It
16
is
of?
on record.
It's on
We have a copy of it.
okay.
It's on record.
It is on record.
Where?
This is a news report.
This dissent note was not sent to the president.
No, but you have filed it and it's on record.
In his, yeah. 12 months.
Mr. Attorney,
Your Lordship, please.
this is an application for permission
I will have to
to
look.
bring on
at the
record by
application
Mr.
because
Shukla. You don't have.
Application jumbled up, try to find out.
We are just trying to find out if you
Right.
have this application, page 121, what is the date of this resolution?
I'll find out.
Page 121, I don't find the
It
date.
is application number one,
This is application number
make a note.
101639 and 138503.
That's your.
To some, I'll find out the application all with me.
13805.
No.
So what is the date of this particular resolution? If any one of you has this,
Which page, Milad, of what? Because too many documents across our petitions. Show me.
Lordship, that's why we have also filed an application for requisitioning the original record, Lordship. That would confirm the documents which we have enclosed.
February, Milad. At the top, it says 17th February.
These minutes.
What your lordships have?
so page 17th February,
It says 17th
I
February.
missed it then.
Lordship has circled it also, my lord, with red.
At the top of
No,
the page.
Held on.
I'm
17th.
talking about 121.
Oh.
Yes, 123, I have circled it. What about 121?
Which one? This one?
There is no date.
I
121, there is
think
no date.
Get a copy of the application first. I'm
It
not, I
says
don't.
16/2 at 11 a.m. Second paragraph.
Where?
A meeting of the search committee constituted blah, blah, blah. About 5 lines down, it says 16/2 at 11 a.m.
Acha, was held on 16/2/2025.
Yes.
Yes.
It's one day before the selection committee.
So therefore, वो बना दीजिए। Mr. Gyanesh Kumar was recommended by the search committee
Yeah.
Correct.
on 16th February 25,
That's what it appears.
right?
Yeah.
Yes.
Then
Yes.
on 17th February 25,
That's what it appears. Yes.
right?
Yes.
Then maybe we committed a mistake in recording the dates in our interim
Order.
order.
I don't know, I took it from the.
No,
I'll check it up.
Because you were very vociferous that everything has happened on 14.
No, my lord, because I said. also-
Maybe we are wrong.
Yes.
You have taken it from our order.
And
But
your
maybe
lordship's
on-
order is based on their affidavit. There is an
I'll
affidavit.
check up all those things, but the application
Your
I don't have.
if your
Let me get a
lordship see-
copy of the application, Mr.
If your
Shukla.
lordship see,
I'll
your
verify.
lordship's order
My,
says,
my.
reading of the
probably my
affidavit
only-
of India.
1 minute. My submission in this regard would be, you also heard Mr. Shukla at great length, I need either not to be stopped. But his first prayer is declare his law is unconstitutional. If that prayer is not granted, in my submission, all other things must.
Yes, you are right.
So don't.
Can you please repeat it? And
I was saying, if the first prayer is not
No,
granted,
you know-
your lordships will not inquire into any other release sought for Mr. Shukla. If
Why-
the act
why-
is valid, if the act is
No,
valid,
even under
be
the,
valid.
I will answer the
If-
question.
Act may be
even
valid.
under the new law,
But-
the
But then,
appointments cannot be
assuming
sustained.
the act is
I'll answer
valid,
the next.
it
As
has
far
to
as
be
the
followed.
petition is concerned, there is no ground made out for your lordships entering into any inquiry whatsoever.
Very well.
They're
That-
all,
that we will
they're all
consider.
roving, fishing inquiries. Just to please your mind.
No, no, Lordship, as I submitted, these appointments cannot be sustained even under the new law, Lordship. So the second prayer also needs to be considered. And Lordship, let me clarify, Lordship,
It was based on an.
dates of both the meetings, search committee meeting and selection committee meeting, as per the minutes which I have enclosed with my application, is 14th of March 2024, just a day before the hearing of the matter in the Honorable Court. Just to avoid that hearing, the original date was preponed from 15th to 14th, and these two committees met one after the other on the same day to finalize such an important appointments. Then
Your
I
turn
was on
comes.
this
Please show us,
minutes
Mr.
of the,
Attendee,
if
what
Lordship
was
permits.
Mr. Sandhu recommended, on which date? What is
I
the
will get
resolution?
all those details, but I have only some, certainly, I trust the
Because-
court.
If he faints on the first round, act is held to be intra vires.
Yeah.
Even then, the provisions of the act have to be followed to the T.
Provided.
Exactly.
Why should the act not be followed?
Provided a good case is made out for your lordship,
So therefore-
engaging in an inquiry into that matter.
In this,
So I will have to
in
first-
this petition,
I don't mind placing everything before the court.
Please get the
I'm not
records.
fighting shy of that.
please get the records with you.
We'll do that, but I'm not fighting shy of that. But I think it's important for the court that when
Okay.
a good case is not made out, your lordship to inquire into that matter, a roving fishing inquiry will be a complete waste of time on this matter. And with regard to
Not
that,
do a
No,
roving
no,
inquiry.
it's a roving fishing
These are
inquiry.
hard
As far as
facts.
the documents which have been placed on
I'll place
record,
all the documents. I have no difficulty at all.
so far as the documents which have been placed on record,
Yes.
it does not appear that.
We
Mr.
have given your
Sandhu's
own
name is-
records.
Mr. Sandhu's name has not yet surfaced in any of the
I'm not
minutes
saying
of-
it's not my record. It's our record. Of course, it's our record.
in the minutes of meeting. We are just inquiring. Please have the records ready
Certainly.
so that you cannot say that the.
No,
court
I'm
can
not saying no.
look into the
I'm
record.
not saying not. I'm not saying no at all. But I think there's some
Very good. Yes,
threshold
Mr.
line.
Shukla, we believe you have made your point. Let us now start with the respondent side.
No. 1 minute, Lordship. No, kindly give me a few more minutes, Lordship, because I mean that is very important. I am coming to the very important points, Lordship. I was quoting this minutes of the approval of the Honorable President, Lordship. As I said, while getting the approval of the Honorable President, no details of these recommended officers were given to the President, Lordship, and the minutes were of the selection committee were not enclosed with this note, Lordship, to the President. That is important. At least the minutes of the selection committee should have been enclosed with the with the note
So
to the
where do you
President,
get it
Lordship.
that these
And
were not
thirdly, as I
given?
said, that the committee in this case,
From which document do you get?
Dear
Do you
Lordship.
form this impression that
Yes.
the president was not given the details?
yeah. This note did not say that the minutes are being attached or are being submitted. This note should have said that it is there.
Sir, I'll give you one example. when a
at such and such page, the note mentions that the minutes are enclosed herewith. It is the general practice in the government.
Sir, minutes are not
Then-
required
then-
to be
then
part of
thirdly- then
forward
thirdly,
of
Just a
recommendations.
minute.
I'll give you one example. When a collegium is held
No.
for High Court judges, please wait. Minutes are prepared, deliberations take place, but finally, what is recommended to the Chief Justice of India or to the government? It's 5 names with the few details. That's all. So it's not necessary that every recommendation should include all 10, 15 volumes of their CVs and everything. No. Where is the requirement of submitting minutes? And from
No,
where you,
Lordship,
as
I'm
rightly
sorry to
pointed
say,
out, from where you get,
The note.
only because it's not referred in the
the note
note.
I
doesn't
just
say
want to
so.
clarify. Just
No,
1
no.
minute, Mr. Chair. I just want to clarify. On your 22nd March 2024 order, your lordships have recorded based on the government's response the following. The search committee in its meeting on 13th March 24, we're talking 24 now, not the 25 which you saw just now. 24 could not finalize and shortlist the names. In the meeting held on 14th March, the search committee recommended a panel of 6 names for consideration of the selection committee, which were then circulated and forwarded to the members of the selection committee, including Mr. Adhir Ranjan Chowdhury. Next para. On 14th March, the selection committee met and recommended the names of Gyanesh Kumar and Sukhbir Singh Sandhu to the President of India for appointment as ECs. The President of India had thereupon approved the recommendation on 14th March 24. This is what your lordships have recorded. It's in your, it's para 6 and 7 of the 22nd March 24 order. So those two were appointed as election commissioners then. The Mr. Gyanesh Kumar's appointment as chief election commissioner comes in 25, which is what your lordships have seen at pages 19 and 21.
But where are
So-
the documents relating to?
That we don't, of
So-
24, we need to have the documents.
We have taken it from the government's affidavit, then filed?
Yes.
Yes.
Yeah, but not the documents. The dates have come from the government's affidavit.
अच्छा गवर्नमेंट का पुराना एफिडेविट देखिए तो है कि नहीं?
The minutes are there. Minutes are not there.
Lordship,
13th March 24 and 14th
Lordship,
March
what-
24, to my knowledge, are not on record. They have not been placed by the government. The minutes which show on 13th March that search committee says we can't arrive at a decision and they leave it to the selection committee. Minutes of selection committee recommending these 2 names to the president. That's not on record from what I understand. They would probably have it. They can place it before.
the minutes of 14th March of both the committees.
That's what. Just show it to courtmaster. He needs to see this.
Which
This would-
Such
your order,
affidavit made.
showing 22nd March order.
No, the reply. Well, sir, we have that. I'm just showing it to the courtmaster.
Affidavit you have there.
That's the affidavit from which those dates were taken. So it's dated. Yeah. It's the reply, conjoint reply that the Union of India filed to IA 68091 in the lead petition. No, it's in writ petition 87 of 24. ADR's in ADR's writ petition,
18.1.
but they didn't file individual replies. IA 68091. Yeah, it will be in your soft copy, no, for the photo in 18.1. Which PDF page? You have the court record.
What is the date of
PDF.
this? Do you have the date of this?
PDF page of this.
That's what they were saying. 10.
10 सही है?
1012. That's it. In the PDF, it's 1012, Maloj Sharma. Okay. Conjoint reply. That's the. So I think it's been put in every file. You have it, Raghav?
Yes. Page number?
No, I know.
Something else.
He's asking.
7 देखो.
No, this is something different.
From, if it starts saying conjoint reply, that's the one.
No, there are 2 conjoint
In
replies.
which, at page 4, you'll find a table, Manoj.
9th March को present किया गया.
You're referring to the table?
Yes, ma'am.
Okay, sir.
Mr. Gopal
Yes,
says that on 9th March,
correct. Yes,
it was advanced to 14th of March.
correct. That's what it says. That's their reply.
That's the reply.
Yes.
That is what has been recorded in the order.
That's what, it's been recorded from here. So what I'm saying is the document supporting each of these, that's not been placed on record. So we have taken their word for it. The court has taken their word, we have taken their word for it, to be fair.
Please don't disbelieve that.
No, that's my prerogative if I want to believe it. But I'm saying we have taken it. And there's this slapdash rush within the next 3 days. All this has taken place. So this is what your lordships are asking is exactly what Lok Prahari has asked for. We have asked for. That show us the underlying minute.
Very,
Very.
yeah. Yes, Mr. Shukla, let us now start with the attorney.
Lordship, I was on the no, Lordship, I was on the
sir?
fourth point that the approval of the honorable fourth point that the approval of
We
the
will look
honorable
into it.
president
We will look
was
into
given
it.
was vitiated
We
for
will
two
look into it,
reasons.
sir. If you fail on the other points,
First,
this is not a point on which you will succeed. That everything was not sent to the president. Sorry, that will not be a point which will weigh with us.
not everything, Lordship. They didn't enclose the minutes of the committee. Then the second, another point is that the committee was not there. As I mentioned, Lordship, as per the 9 judges and judgments, Lordship, committee means all the members. And this fact was concealed from the president, and therefore there was no application of mind at that level. And the approval was obtained concealing this fact that one member has dissented. It was not a recommendation of the committee as wrongly mentioned in the note. This is a very important point, Lordship. How would the president know that the third member has given a dissent note, Lordship?
Not, my lord. If your lordship permit me, the constituent assembly debates I have placed before your lordship. Lord.
Yes.
There is a similar constituent assembly debate for Article 124, raising similar concern that we can't leave it to the executive. And that is the basis of your lordship judgment in second judge's case and the fourth judge's case, my lord. I have, my lord, and I can give your lordship the page numbers of the debate. Identical concerns are raised that we cannot leave it to the executive. And that's what your lordship accepted in the second judge's case and the fourth judge's case, my lord. I want to place that, my lord. Just by effect, uh, 24th May 1949.
Request to you.
I'm
One consolidated paper book of all.
yes, my lord.
Because we don't know sometimes. Yesterday
understand.
Somebody was making an
If
allegation.
that's why your lordship
towards
has
me.
marked his volume number.
Somebody made an
I
allegation
understand.
towards me that I have not.
Your
noted
lordship has
down the
noted the
exact
volume
number.
number. Last volume was marked as number.
So, sir, one consolidated volume of everything
I understand. Very well. I will do that.
at the end of the.
No.
I mean, after the hearing is over.
Very well. At page 231. I'll just-
Actually, you know, Mr. Ansari,
very-
we are witnessing strange things. A party who wins is still aggrieved because his submission has not been recorded.
No,
Yeah, yesterday only.
very well. Lord.
And the answer was your submissions were useless or were of no help, and therefore they were not recorded.
But still you won.
And still the judgment is in your favor. So that is why my
Very well. I see. Ma'am.
request to you
I-
is,
I-
please give one volume.
Very well. I'll make a compilation, make one volume, my lord, and give it to you.
Yes, which page?
Which this page 231, my lord.
231.
231 is what Sibalal Saxena has said. At present, clause 2 provides the president shall appoint the Chief Justice of Supreme Court. That means the Prime Minister or the Executive shall appoint. The Chief Justice of the Supreme Court should be completely independent of the Executive, and that's exactly what said for the Chief Election Commissioner. And it is this principle which I want to introduce in this section. At present, I shall be creature merely by executive. The president shall appoint him on the advice of the Prime Minister. This will take away some of the independence of the Supreme Court. We are hereby providing for the highest tribunal of justice in our country. The tribunal should be above suspicion so that no executive would be able to have any influence upon him. If the Chief Justice of India is appointed by the President or the Prime Minister, then his independence is compromised. But similar, my lord, views were expressed, my lord, which I have shown to your lordship, my lord, for the chief election commissioner, and this is, my lord, and I'll just only 258 is Ambedkar, my lord, what he has said also, similar things. The Professor K.T. Shah has said page 240. Page 240 top is Professor K.T. Shah. This follows the general principle I've been trying before this house, that is to keeping the judiciary completely away out of any temptation, contact with the executive or the legislative side, while during his tenure in the ordinary course of judgeship or even retirement. I would suggest there should be constitutional prohibition against employment, temptation, etc., etc. And finally, my lord, I just, because at 258, what Dr. Ambedkar has said, my lord, I'll conclude with that. Yes. With regard to this matter, 258, about third paragraph, my lord. With regard to this matter, I quite agree that the point raised was the greatest importance. There can be no difference of opinion in the House that our judiciary must be both independent of the executive and must also be competent in itself. And the question is how it is to be, these two objectives could be secured. There are two different ways with which this matter can be governed in our countries. In Great Britain, the appointments are made by the Crown without any kind of limitation whatsoever, which means that the executive of the day, there is an opposite system in the United States, for instance, where the officers of the Supreme Court as well as other officers of the state will be made only with the concurrence of the Senate. It seems that to me, in these circumstances in which we live today, when there is a sense of responsibility has not grown to the same extent as we have found in the United States, it would be dangerous to leave the appointment made by the president without any kind of reservation or limitation, that is to say, merely on the advice of the executive of the day. Similarly, it seems to me, concurrence of the legislature is also not suitable. My lord, what I'm trying to say, my lord, that parallel concerns were raised by the members of the Constituent Assembly regarding the judges of the Supreme Court and the Chief Election Commissioner. And that's why your lordship in the second judge's case said that we cannot leave it completely with the executive. And that's why in Barnwal, your lordship, the reasoning behind Barnwal is it cannot be left completely in the hands of the executive.
Right.
And my lord, one more thing, my lord, one more last thing. Your lordship has seen, my lord, the search committee in how it is seen, my lord, just now. Same day, 14th March, everything happened. My lord, I have a suggestion, either way, my lord, whether your lordship upheld it or, my lord, it rejects it. Some procedural safeguard must be there in the manner in which the search committee or the selection committee must function. And which is, my lord, I have just, that's so that this can also be responded, my lord, by the government. Now, lordship has seen search committee. There is no guideline as to who will make the search committee. In the Lokpal Act, there is a provision that the search committee will be constituted by the selection committee. Now, since in Lokpal, that provision is challenged. In my petition, it was not challenged, so I didn't argue. Search committee under Section C shall be constituted by the selection committee at least 2 months prior to the consideration of filling of any vacancy. The search committee shall prepare the panel of 5 persons for consideration of each vacancy at least 1 month before the vacancy. Every member of the selection committee shall be entitled to make inquiries from its own source or from any other government agency about the candidates recommended by the search committee. Every government agency shall be bound to give response and furnish information sought by any member of the selection committee. The members of the selection committee shall be given at least 2 weeks advance notice before the date of the meeting for selection of the chief election commissioner, so that the process which happened, my lord, in the case of last appointment, it does not happen. And there is no, my lord, guidelines. There is no question of, my lord, anything contrary to the statute. It only says this procedure would be decided by the selection committee. There is no decided procedure. That's why on 14th March, everything happened. And there is no requirement that when is the search committee, how do they constitute and when do they recommend? Look, purpose is the meaningful discussion. Now, even if the Chief Justice of India is there, my lord, he is given on the same day, the names. Lord, there is no meaningful and effective discussion. And these, my lord, suggestions in my respectful submission will take care of it in that eventuality, my lord.
Well,
I'm extremely grateful to your lordship.
yes.
Lordship. I have my written note ready, but before I take your lordships in some length into that, I keep wondering, when you open up an invitation to the court, that here we have a set of precedents which say how Parliament will probably focus attention to our observations, concerns, stated by way of norms, principles. And if Parliament does not, as the court desired to happen, did not focus attention on that, somebody will come back to the court and say, Parliament, invoking administrative law principles, did not apply its mind, disregarded your judgment, and therefore they were bound to act entirely in terms of the judgment of the court. Anything with the Parliament to choose otherwise would be not in consonance of what principle, I'm not able to understand. What's the principle which somebody can place before the court to say the Parliament's authority to not to abide by or not to go by or to deviate from a principle or a norm set down by this court will be tested on what principle? You are lots of being asked today to enter into that domain. I am not talking about whether 142 is a reservoir for doing complete justice. When court lays down certain principles or norms, in certain circumstances, one of my submissions going to be that in the context of illegality of particular legislation, testing the legality of the legislation or state action, the court enters into a declaration of law exercise. Where a declaration of law happens, testing the legality of a legislation or any state action, the court they say this law is bad for the following reasons. The court will not go thereafter to say what would the law look like or what should the law look like. But in a case where there is a need for the court entering into doing complete justice, the court may then say, please consider the following ways of doing complete justice. So we have had all those varied circumstances 142 has been invoked. That will stand entirely different footing. Therefore, my first proposition is Anup Baranwal is not a case where a legislation was sought to be put to test. There is no declaration of law in that strictest sense for the purpose of Article 141 of the Constitution. It's a case where people came to the court saying, for so many years, for 75 years, Parliament has not enacted a law. And there are several reports and commissions which apply their mind in the regard to what could possibly a law look like. And therefore, there is a vacuum. We in the context of the vacuum, the court looks into 3 or 4 propositions, which would probably appeal to the court. 1, 2, 3, 4, 5. The court picks up one proposition. I'm not entering the question whether the Anup Baranwal 5 judges were in wisdom in picking up one particular proposition. I'm not entering into at all. I'm not asking lordships to sit in judgment or an explanation about what Anup Baranwal said is correct or not. But therefore, if it is not a case of, not a declaration of law, in the strictest sense of the term, then today, your lords are being asked to act as an executing court of what Anup Baranwal has said. In other words, Anup Baranwal number 1, if the lordships thought, there will be Anup Baranwal number 2. The court thought, I will beget another Anup Baranwal, where this court will sit in execution of a previous order. We are entering into a very different, a thick boy doing, he is now getting into it. It's a very important question for the court. All of us are certainly concerned about free and fair election. Nobody has disagreement about that.
Mr. Attorney, let us be very clear on one point.
Yes.
We feel that Anup Baranwal
Yes.
is a classic case of judicial restraint and statesmanship. Anup Baranwal consciously insulated itself from laying down a law under 141. If it had done so, it would have been accused of judicial legislation.
It had no occasion to do so.
It could have, it did not. It only laid down broad norms which are to be kept in mind. Now, why was it required to do so? Baranwal plays the history, 70 years, no law. Then, by its order constituted an interim committee, which was to function till such time law is laid down by the Parliament under 324.
Can I halt here for a minute, Lord's, for permission? If during that interim period, if the executive had not acted in terms of that interim arrangement, the position would have been different, right? The question would be then, till what time will that interim arrangement last? If it will be a purely interim arrangement, because if there was, what you'll also make a note about this point, that when Anup Baranwal initially came in 2015, there was a vacant post of an election commissioner. It was in that context they wanted the court to engage in and find out which is the best way of going about appointment of election commissioner. By the time the judgment came, the position is different. Therefore, if it's an interim arrangement, because
What we want from you is this.
Yes.
You know, arguments have been advanced from the side of the petitioners
Sorry.
challenging the law on two basic grounds. One seems to be that Anup Baranwal has been violated. We are not on that.
I'm also not on that.
We are not on that.
Yes.
You will have to address us on the point that the virus is being tested on the ground of Article 14, read with 324. Free and fair elections have been held to be basic structure that can be accomplished by an independent ECI.
Yes.
Now, ECI can only be independent if it has independent commissioners. Now we come to the basic fact, whether the commissioners, in the manner they are sought to be appointed under the law, whether it is contrary to 14 and 324.
So we are critical situation. If this law is applied the way it has been applied, they will, for all practical purposes, the only outcome will be they will lack independence.
Because the judgments of this court from 1950 are eloquent on this proposition that the executive cannot call the shot as elections are concerned. It's not only Anup Baranwal, there are different other. Right?
Today,
so therefore, you will have to address us from that angle.
I will do that. I'm not going to fighting shy of that. But some basic concern is what is bothering us. If therefore, whether we'll test the law without reference to Anup Baranwal, either we test it with the reference to Anup Baranwal at all. In which case, we close our mind to the history of entire history, what is stated in Anup Baranwal, and see as if the Parliament has enacted a law for the first time today. Then it will be an entirely different way of testing this legislation. But Anup Baranwal casts its shadow, whether you like it or not, in the reasoning which would probably get into the adjudications matter. It just can't be kept aside. Therefore, I understand if that judgment, good or bad, right or wrong, if it is kept as a platform for a further reasoning to persuade the court to say this act is bad for the following reason, I would probably say, unless it is tested on the actual application of the law, the Chief Election Commissioner and the Election Commission appointed have actually displayed a lack of independence in the actual functioning. The actual functioning lack of independence is different from saying, if you follow this law, perhaps you will have election commissioners who will definitely lack independence. It's a huge hypothetical, argument being placed before the court. I'll try to make good this argument, but my concern is that if we have to take this court into a, as I said, the Anup Baranwal number 2, for the sake of argument, I'm using the next. The court is being asked to say that if there are certain precedent that tells us how legislature should have probably, apply their mind to it, legislature has not done so. Therefore, we will examine the question as to what probably and in what best manner the legislature would have applied its mind. So this court, in another way of speaking, is being asked to enter into the legislative arena. In a way, you probably cannot. It may
legislative wisdom.
No, I'm talking about the legislative arena.
We are questioning legislative wisdom.
It's
only that
yes.
When the Supreme Court speaks, the legislature cannot say that.
If today, for instance, there's no Anup Baranwal at all, Parliament chose to enact this law, and it's ought to be put to test again for the first time before the court. The court will look at it from certain facts we plead before the court, and facts will probably carry weight with the court. So to say that merely because for a long period of time, and for good reasons, I'm not saying discounting them, from the Constituent Assembly debates onwards, the independence of the Election Commission, there can be no other point of view on that. Nobody can say no to that proposition. But merely because the executive cannot have the exclusive stay, then how do you really test? The test of the pudding. You must eat the pudding and find out whether the pudding is bad or not. Therefore, your lordship today being asked to enter into a pure legislative arena. And why is it so? On the basis of what certain set of precedents have said that so the basis. That's going to be a very problematic area. You lordship, for good reason, say election commission.
test-
We need free and fair elections.
We'll test it.
Yes.
We'll resume after
I
recess.
thought I'll open up some concerns here. It's not merely a mere response to this case. It's something which is broader, very, very broad.
The question of constitutional credibility also, sir. We'll come back at 2.
The district judge says, because they asked the officer, the PP, my lord, you've not arrested her. They said, actually, we didn't find any money trail. There is no connect in that sense. He says, surrender within 7 days. The High Court, my lord, replicates the same error. And your lordships have said, my lord, apart from anything else, that if you're rejecting anticipatory bail, you can't direct arrest. That's the job of the police.
You will be happy if we delete
No,
that
no.
part.
And not only that, I'm saying
The-
this is something that the courts below are not following at all. Now, please see the police's stand. Please see paragraph 9, my lord. My lord just obliged me.
It's just a change of a baby, right?
Yes, my lord, because someone said,
Now you are a nursing officer.
I am a nursing officer.
They have some call detailed records, they have some CCTV footage.
No,
Right?
not with me.
Yes,
Can-
FSL also is there.
if
Huh?
you-
FSL
yes.
also. The
My lord,
scene
I-
happened in the maternity
Can
center.
can I just complete because my lord is putting a question.
I want to correct myself. It's 60 people per day. It's very small babies.
Now, please,
So I want to correct because I
no, my lord,
it's the
it is
wrong
a
thing.
problem. My lord Justice Sharma is right. It is a problem. In fact, my lord,
problem.
now please see paragraph 9. My lord, please see page 34.
How
My
to
lord,
find out if somebody is innocent
my lord, please.
at this stage.
No, I'll tell my lords why in this case, my lord. Please see page 34. My lords will
Page?
apply. 34, my lord.
34.
This is the district court's judgment, paragraph 9.
This country.
Paragraph 9, my lord. Now, my lord, please see paragraph. This is what is recorded. The district judge says, my lord Justice Datta and Justice Sharma, please oblige me by turning to
Yes,
page 34.
para 9 page
That
34.
Yes, my lord,
I'm
this
not
is part
saying
of the trial court
discounting
judgment.
them. From
In
the
this case, as
Constituent
noted
Assembly
above,
debates
the
onwards,
applicant, that is
the
me, has been
independence
sent
of the
for trial
Election
for grave
Commission,
offences,
there can be
etc.
no other
traffic
point of view on
incident.
that.
Applicant is working as a
Nobody can
nurse
say no to that
at a
proposition.
public health center,
But
and
merely
as per
because the
allegations,
executive cannot
the
have the
accused
exclusive
Devaki
stay,
approached her
then
saying that
how
she
do you
wanted to
really
give
test
her, this is the, my lord, the
test of
so-called abductor,
the
wanted to
pudding?
give
You must
her,
eat the pudding and
give away
find out
her
whether
child.
the pudding
The
is bad or not.
prosecution appears to
Therefore, your lordship today
concede
being
that
asked to enter
surely,
into
that is the
a
petitioner before my
pure
lord,
legislative-
Sheila, my
legislative
maid,
arena.
Banita and Dheer Singh,
And
this is
why
the
is it
couple
so? On the
which
basis
wanted
of
the child, may
what
not have had
certain set of
knowledge that
precedents have said
Devaki
that
was
to the
not
basis.
the mother of the
That's
child, the
going to be
birthing
very
mother. my lord.
problematic area.
Bona
Your lordship,
fidely
for
believe
good reason,
my
say
maid
election
said their
commission says
brother-in-law
we
and
need
sister
free and fair
wanted a
elections.
child.
We'll test
I
it.
just put
Yeah.
them in touch.
We'll resume after
Now, my
recess.
lord,
I'll
please
open
see
up some concerns here. It's not merely a
11.
mere response to this case. It's something which is broader, very, very broad.
The question of
Now, of course,
constitutional
then 11 and
credibility
12. And if your lordship would see, then in paragraph 15, my lord, the trial court says surrender
We'll come back at 2.
within 7 days. The High Court, my lord, as I just informed my lords, says the same thing. But see the reply of the prosecution. Why did they not arrest me, my lord, is very crucial. Place 27, my lord. I have no, you have no charge sheet has been filed. So at this stage, in fact, my lord, I am told, my lord, when it first came up before the High Court, my Lord, though not relevant, would my Lord just first turn to page 27 is the reply to my application and 28 paragraph 5, my Lord. Paragraph 5, my Lord Justice Sharma.
Paragraph 9,
5, my Lord.
5.
Page 28. This is the reply of the prosecution, my Lord. Accused,
So where is the apprehension now?
my Lord, after the charge sheet, because,
After if they have not arrested you prior to filing of charge sheet,
yes, my Lord.
they
Now,
are seeking anticipatory, there has to be an apprehension
no,
of
the apprehension is because the,
filing an anticipatory bail.
my Lord, because the trial court said that. In fact, the trial court confused.
What did the trial court say?
My Lord, I just showed my Lord. In fact, my Lord, the trial court said within 7 days.
Well, the
No, because-
anticipatory bail, where was the apprehension?
My Lord, my Lord,
If they say.
I'll tell
this
my
is-
Lord,
This
my Lord,
is submitted
a lot of
in
things.
April 26, right?
What happens when you appear trial court says, oh, you've arrested XY, only Banita has got bail. That's the adoptive mother, my Lord. She got bail because she has 4 girls, my Lord. Now, they said, what did you do with your...
Why do you want to take
But
him,
it's charge
take
sheet
her
is
into
filed.
custody now?
There's no apprehension of arrest here.
So we'll record that,
No, my lords,
dispose it of.
no, my lords, the need, it might, in future, if some need arises, we cannot say, but right now there's no,
what you want to arrest her?
my lords, we do not want to arrest her, right?
That's good enough. Stop there only.
My lords, the charge sheet has been filed. My lords may understand, my lords may appreciate. Only thing, right now, till
The entire investigation, she was not arrested.
she was not arrested, my lords.
You don't want to arrest her.
No, my lords, all I am submitting at this stage is that, my lords, presently, if she's cooperating, there's no apprehension.
Required for
But-
further investigation, she shall join. Allowed.
Deeply obliged, my Lord. My Lord, but this, I don't know. I'm just replicating this law of directing arrest, my Lord. All of them are saying this. The
All of
trial-
them are?
My Lord, when an anticipatory bail is rejected, your Lordship have said the courts have no jurisdiction to say arrest.
You reject it.
No, I'm just saying your Lordship needs to re-emphasize this. This is happening.
Justice Padiwala has said just a week back.
Lordship knows, but then this is still happening at the High Court level. I don't know, whatever matter, my Lord. Your Lordship may do it in some other matter, but this is happening. I could have understood the district court doing it, but the High Court doing it and not reading your Lordship's judgment is.
What do you mean to say?
But High Court must have dealt with this matter before Justice Padiwala's judgment came.
I leave it at that, my Lords, before that.
One of the finest judges in that order.
You're right.
A mother. A
Well,
mother.
my Lord, I know.
Yeah.
May it please, my lords. My lords, here the direction was to consider his appointment if there is no other legal impediment. We have done that. The rules require that he should have a.
So
type
what
of
happened
speech-
on 17th April? You
Yes. sought
for an adjournment.
Yes, my lords. In fact, I filed an additional documents.
Acha.
I put all the
court has
other
kept it
orders.
When?
My lords, this was filed yesterday. There are 3 additional documents.
15th.
So the matter is now listed tomorrow. So my lords, first it was listed on 1st May. After that, we filed an additional on which date we were told to explain why the 2015 rules will apply and not the 1974 rules. This is all contempt jurisdiction, my lords. That is the first. We filed that affidavit. Then the matter gets listed on 17th April, my lords, page 8 of my additional documents. There, in this case, on the issue of applicability of the 1974 rules, we have to file another affidavit.
So where is the order of 17th April is quoted?
Yes, my lords, page 8.
Page,
8 of my additional documents, my lords.
page 8. Now, did you
It's-
personally appear?
No, my lords, after that, we did not personally appear. We filed the
You did
affidavit.
not pay the cost also?
My lords, I think the cost has been paid. I am not,
Cost has been paid.
my lords, I will have
So
to
if the
check.
cost is paid, you're exempted from personal
My lords,
appearance?
I will have to, I will confirm that, my lords. I will take instructions on that. The issue is not this, my lords, the High Court can decide the matter.
The issue.
They may just require us, because they are constantly seeking affidavit after affidavit going into the merits of the issue. The merits of which rule is applicable. The order of 3/12/24 just said, consider the appointment. We have done that. We have filed 3 affidavits stating that. Yet contempt proceedings continue. That is what we are troubled by, my lords. My lords, in fact, if my lords see page 60, that is the operative order. Para 14. Are my lords at page 60, para 14?
No, we thought that you were aggrieved by the order requiring you to.
My lords, we are
Take
aggrieved. That,
Now, if you have paid the cost
my lords,
and if you have filed the affidavit, right, question of personal appearance does not arise.
my
Now
lords,
you will have to fight out the contempt proceeding,
my lords, we will
persuade the court to hold that there is no contempt.
my lords, we will do that. My lords, this is in fact,
So we
the cost
want
is
to know
not,
what is the purpose of considering the SLP now
I bow down,
in
my
view of the
lords.
subsequent orders.
Yes, my lords, I bow down. My lords may just, in fact, the cost is not linked to the appearance. The question,
Why?
no, my
Yes,
lords,
no.
because the affidavit is
No.
5,000 costs for the applicant for harassment and compelling him to file this contempt petition. That is the cost. The summoning is to explain why he has been disqualified, even though an affidavit has been filed to that effect. His typing speed is 26.3 per words per minute. The rules require that it has
Please
to be
come
30.
to para 5 of the impugned order.
Yes, my lords.
For harassment and compelling, forcing him to file this contempt petition application,
Yes,
and also for not complying the order in issue within time.
yes, my
And if that is done,
Yes,
then the respondent chairman concerned need not appear.
yes, my lords.
So if you pay that 5,000, you are exempted from appearance. If you have paid that 5,000 already,
Yes, my lords.
you
My
need
lords,
not
if-
appear before
if
the court.
We have filed the affidavit. The affidavit is on record before my lords.
Let the court consider
lords, we
the
just-
contempt.
My lords may just.
What order do you want from
I
us
just-
now?
My lords, we just want an order that the High Court may decide the matter without calling for further affidavits and
No, how can
appearance.
we say that?
At least without,
Well,
my lords
you
may
may have
just, my
filed
lords may
3,
dispose
You may
of.
be required to file 10, but we cannot tie the hands of the High Court like this.
Very well. My
So
lords,
don't call for any further affidavit.
my lords, personal appearance may be exempted because we have already filed 3 affidavits.
If you have paid this 5,000,
Yes, my lord.
you are exempted by the very terms of the impugned order.
Yes, my lords. My lords, in fact, it is the affidavit explaining that because there are 2 parts to the order. One is 5,000, the other is to explain why you have not given him appointment. The costs have been paid.
It's not like that.
Let the High Court pass such an order, thereafter you come.
Very well. My lords may then just say that the High Court may decide the matter expeditiously.
Having heard Ms. Goyal, learned counsel appearing for the petitioner, and in view of the development subsequent to passing of the impugned order dated 10th April 2026, we see no reason to issue notice to the respondent. The High Court is seized of the contempt application filed by the respondent. Affidavits have since been filed by the petitioner, being the contemner before the High Court. We hope and trust that the High Court shall proceed to decide the contempt application in accordance with law upon taking into consideration the affidavit so filed.
I am so grateful, my lords. Lords may say alleged contempt now instead of contempt now. If grateful.
Nothing turns on it, madam.
Lord, here all I'm saying is that before my properties are sold, my cases they are being sold at an undervalued. Please hear me.
No, you
The
filed a precipice.
I filed a precipice,
What happened then?
rejected. So the precipice was rejected for urgent circulation. Then we mentioned it on the next day. That is also rejected. In the
No, it
meanwhile,
was rejected without costs. Because the judge's note says that
yes.
if any frivolous
no.
precipice is filed,
No, there were no
that will
costs.
be dismissed with costs.
No,
So
not.
your
That was
precipice
just
was
not
not to
granted.
that extent that it deserved a cost.
Fortunately not, my lord, but it was just rejected.
DRT order, there's an appeal before DRA.
Yes, my lord. What has happened is the DRT has rejected my application solely on the basis of my consent terms with the bank in the High Court. So I moved an IA in the High Court that please clarify that consent terms will not come in the way of my challenging the sale.
Because petition itself was not maintained.
So, my lord, no, what I did was I moved an IA for clarification. I filed a writ petition so that both are heard together. Because in the meanwhile, otherwise my properties are being sold. My 4 properties are being auctioned. My cases, they're all being
Even
sold
if
at
your
an undervalue.
property is sold today, Mr. Mehta,
Yes, my lord.
but ultimately the DRAT or the DRT or even the High Court finds
Yes.
that the law has not been followed.
Yes, my lord.
17(3) will come into force.
I appreciate that, my lord. But
We'll get back.
in the
everything.
meanwhile, my lord, the
In the
point
meanwhile,
is,
what will happen?
I am
The
trying
auction
from-
purchaser will be divested of some money.
first I was told that it must go before the very same bench for clarification. Thereafter, that bench was not available. They were sought to be constituted. It was not constituted. Then it was assigned to another bench. That other bench said, please re-verify whether it's assigned to us. Ultimately, I landed up in the summer vacation. Now, my lord, I had to file the writ petition so that in the meanwhile, pending my application for clarification, the properties are not fully sold. I have 4 properties. I've made out a case that the properties are being sold at a value which is less than the value at the time when I mortgaged the property. So, my lord, all I'm saying is the High Court, let the High Court hear me. Cure also, all I'm saying is,
Which one?
because there's no practice of passing an order, your lordship knows, it's just not granted. That's it. There's no written order on this, my lord. Lord, all I'm requesting is,
We also don't give any written order while.
Mr. Mehta, and senior counsel appearing for the petitioner submits that the vacation bench has rejected the precipice moved by the petitioner for urgent hearing of his writ petition.
Lord, and my IA also, I'll give that number, my lord, because both have to be taken together.
Considering the stage at which the writ petition was sought to be moved by the petitioner, we dispose of the special writ petition with a request to the Chief Justice of the Bombay High Court, or the administrative judge in charge at Mumbai, in the absence of the Chief Justice, to assign the writ petition to an appropriate bench for early listing and consideration.
Lord, my IA is also, the number is 89082.
The interim applications, if any, filed in connection with the pending writ petition may also be listed together.
Mobilize.
Somebody else is speaking.
Before your lordship.
Yes, Mr. Shukla, start.
Before your lordship turn to Mr. Shukla, just one correction I made with your lordship's kind indulgence. In the last order, there is a minor mistake which may have some confusing effect on your lord.
Yes, what is that
The
mistake?
last order dated 7/5/2026.
7th May, yes.
Yes, the writ petition 191, last line of paragraph 4. It is actually writ petition number 87, not 191. Where I have filed the written submission as well as impleading application.
Yours will not be 191, it will be
87. 87
87.
2020. Lord, may kindly order that correction. Because it's a signed order.
a correction shall be inserted in the last but one line of paragraph 4 of the order dated 7th May. WPC 191 of 2024 shall be corrected to read 87 of 20.
Extremely grateful.
Yes, Mr. Shukla.
Yes, Lordship.
Yeah,
May it please your Lordships.
Dr.
In our writ petition, Lordship, in our writ petition at 18.5, we have challenged not only the sections 6, 7, and 8 of the 2023 Act, Lordship, but also the appointments of the CEC and both the ECs made thereunder, Lordship. The basis of our petition is not merely the judgment in the case of Anup Baranwal, Lordship, but proven legal infirmities in the impugned provisions and the appointments made thereunder based on the government's own record, voluminous record I have obtained under the RTI, Lordship, which I have annexed with the in the writ petition, Lordship. So our petition is mainly based on the government's own record, which proves the proven illegalities, Lordship. Then, Lordship, despite the order dated 7th of April of your Lordships, giving last opportunity to file counter affidavit by the next date, that was 6th of May, Lordship, no counter has been filed as yet by the Election Commission respondent number 2 and the private respondent number 3, 4, and 5, the CEC
Yesterday
and
we
both the
received a
ECs,
copy of the
Lordship.
counter.
So,
You have not
against
received it,
them,
Mr.
the
Shukla?
It's been sent to him.
We received a copy
Yes,
of the
Lordship.
counter
Yeah,
affidavit.
I'm coming to that, Lordship.
Yesterday
No,
evening,
Lordship,
we have received.
I have received
counter.
a copy of the
it?
counter.
Have you received copy of the counter?
Yes.
No, only the. No, Lordship. No. ECI has not filed, nor the private respondent. Only the Union of India Lordship has filed the counter only yesterday,
do.
Lordship. And
ECI,
on that, yeah, only the Union of India has filed only yesterday without any application for permission to file it as required by the earlier order, because the last date for
have
that
you
was
received
6th of
it or
May.
not, sir?
They have filed it yesterday, Lordship,
You have
without
received
any
the copy?
application for
You have received the copy?
Lordship. Yeah. I have received a copy yesterday, Lordship.
Without
And I shall be
application,
replying
they
to
have
that at
granted.
the end of
We
my
are taking it on
submission.
record. Please address us on merits.
Yes, Lordship. I'm sorry.
Please address us on the merits of the matter.
I'm sorry, Lordship. I didn't get it.
Please address us on.
Yes, Lordship. That is what I propose to do, Lordship.
Yes.
Yes, Lordship. My submission is that I'll talk about the counter later on after I have finished presentation of our case, Lordship. Since the historical background of the framing of Article 324 and the enactment of the new act has been already dealt with in great length, I shall confine myself to the validity of the impugned provisions and the appointments made thereunder, Lordship. That the impugned provisions are ultra vires, Article 14 and 324, as interpreted by the Constitution Bench in the case of Anup Barnwal. And they failed to, Lordship. The important point is that they failed to take care of the serious lacuna which was fully accepted and shared by Dr. Ambedkar in his reply to debate on Article 324, Lordship, which I have reproduced in para 17, Lordship, of my writ petition at page 11. Kindly permit me to read just one sentence, opening sentence of that para 17 at page 11, Lordship. That replying to the debate of Dr. Ambedkar had said, and I quote, "There is a great deal of force in what my friend Professor Saxena said, that there is no use making the tenure of the election commissioner a fixed and secure tenure if there is no provision in the Constitution to prevent a person who is likely to be under the thumb of the executive lordship. This serious lacuna was accepted by Dr. Ambedkar, but the new act also, it fails to take care of this lacuna, Lordship, apart from violation of Article 14, Lordship, which I shall come to later, Lordship. Then, Lordship, consequently, the impugned provisions
Please continue, sir.
Dear Lordship. Consequently, these impugned provisions, they give a free hand to the executive of the day to misuse the power of office, as has been, they have misused the power given by the act to them. Confirming the observations in para 204 of the lead judgment in the case of NJAC, NGSC case, wherein it was said that, and kindly permit me to just read two sentences from that para 204 of the lead judgment in the NGSC case, Lordship, wherein it was said, what emerges, I'm quoting from para 2, just two sentences to save the time of the Honorable Court. What emerges is trappings of the spoil system and nothing else. This is what the court had observed then, Lordship, which is happening, coming to be true even every successive day. Lordship, that was the first sentence. The other sentence in this very para, the Lordship observed was, demonstratively, That is exactly what has happened repeatedly in the matter of non-judicial appointments like this, like the present one. So what the Honorable Court had observed in the case of NJC is being repeated in this case also has been repeated, Lordship. Then, Lordship, now, yes, Lordship. Now I'll come to the impugned provisions, Lordship, as to why they are untenable. Lordship has brought out in paras 45 and 46 of my writ petition as page 27 and 28. 27 and 28. Approval of the cabinet and the parliament on the 2023 bill was obtained by concealing the relevant material like the report of the National Commission to review the working of the Constitution and the report of the Law Commission. Those were not brought to the notice of the cabinet and while approving the cabinet note while approving the bill for presentation in the parliament, nor were they brought to the notice of the parliament. And their approval was obtained by concealing these reports, and it was given without application to these reports, Lordship. That is my point, and that.
Sir, where is the
That's
cabinet?
why that approval was vitiated, Lordship, both of the cabinet as well as the.
Is the cabinet note on record?
Yes, Lordship.
Is the
Yes.
cabinet note on record?
Yes, Lordship. I have filed a copy of that. Yes, Lordship. I have annexed it with my petition. I obtained it
Where
under
is
the
it in your
RTI Act,
petition?
Lordship.
Which page?
The cabinet note which was put up to the cabinet.
Where is it in your petition?
Lordship, 1 minute. It is in the petition, Lordship. It is there. It has been filed in the petition. Lordship, 1 minute. Note for the cabinet, that is at page 96, Lordship. I obtained it under the RTI Act, Lordship. From page 96 onwards, it is the cabinet note. It is totally silent about these two reports, Lordship.
दिखाइए.
Yes, Lordship. So that was my first point, that the approval on the bill was obtained by concealing these reports from the cabinet as well as from the parliament. Then second point, Lordship, is, if I can, yes. The second point is that the statement of objects and reasons, Lordship,
Give it,
which
madam.
is at page 104 of my statement of objects and reasons of the bill for this 2023 Act, that is on page 104 of my writ petition, Lordship. Annexure, it is annexure P8 at 104.
Yes.
Yes. Lordship will be surprised to see that this SOR did not even mention the grave legitimate concern of the frame to intervene, leave alone indicate as to how the bill took care of it, Lordship. They didn't bother to address this issue in their statement of objects and reasons for coming up with this bill, nor it gave any explanation for changing the selection committee named in the Constitution Bench judgment, which was as per recommendation of the Law Commission, Lordship, which was concealed from the cabinet and the parliament. They didn't give any reason for not, they didn't consider even the recommendation of the Law Commission, which was as per the judgment in the Varnamal's case, Lordship. So that is significant. This is the second reason as to why the approval of the parliament was vitiated, Lordship, on the act. Then,
It's also there in the SOR.
yes, Lord. Lordship, then the impugned provisions in section 7 and 8 of the Act, which are reproduced at page 23 and 24 of my writ petition, and they are also in Appendix B to the writ petition.
Yeah, yeah.
Yes, sir.
Yes, Lordship. These section 6 and 7, Lordship, they do not meet the requirement of the selection process, ensuring the four fundamentals of the election commission: impartiality, fearlessness, transparency, and purity, stipulated by the constitution makers while enacting Article 324, Lordship, and mandated in the judgment of the Constitution Bench, on which, Lordship, this is important, the Minister for Law and Justice had also agreed in his reply to the debate on the bill. He agreed with these four requirements of the Election Commission, but he brought a bill and got it passed which don't meet these requirements, Lordship. This is the difference in what is said and what is done, Lordship. In view of the law laid down by the Constitution Bench in S. Krishnan versus the State of Madras, Lordship, AIR 1951, Supreme Court 301, AIR 1951, Supreme Court 301, and 1951 SCR 621, Lordship. The same citation, same case, different citation.
You are
That
relying on
any
which paragraph,
enactment
sir? Which
passed-
paragraph of this judgment?
Sorry,
Which paragraph of this judgment you are relying on?
I've got the page number at 624. This is said. What I'm quoting, the judgment is reported at 621, but the sentence I'm going to quote is at 624, Lordship. The
This is from the
their
SCR?
observation, the Lordship's observation, that any
नहीं नहीं AIR
Yeah.
बोला 301.
yes, sir, 1950 yes, Lordship, 1951 SCR 621. Sorry, page 634.
Well, SCR.
Judgment is at 621, and the sentence I'm quoting is at 634, wherein it was held that any enactment passed with the purpose of defeating constitutional provisions, like in this case Article 14 and 324, can be assailed on the ground of being a fraud on the Constitution. So this act also, Lordship, is nothing but a fraud on the Constitution, in which, in view of the reasons which I have mentioned and I am going to mention further. So
Laptop लाने
this is the submission as regards section 6 and 7 for both. Now I'll deal with these sections separately, Lordship. That is the general point applicable to both the sections, Lordship. Then section 6 relating to search committee is liable to be struck down for the 3 reasons which I have mentioned in at page 2 of my written submission. Lordship, I had filed my written submissions in this matter, which were circulated with the office report dated 5th of May, Lordship. That is important. These written submissions are already on record, Lordship. They were circulated with the office report dated 5th of May this year, Lordship. So I'm only referring to the submissions in those written submissions, based, of course, on the pleadings. So, Lordship, the search committee is liable to be struck down.
Yes.
Yes, Lordship. The first reason as to why Section 6 needs to be struck down is that the amendment to Clause 6, Lordship, to the bill was moved by the minister without the requisite approval of the cabinet under Rule 4.1 of the Government of India Transaction of Business Rules 1961 and was got passed by the Parliament, concealing this fact, hence cannot be sustained for this reason, Lordship. This amendment was not got approved by the cabinet because for the reasons which I have mentioned in para 49, Lordship, of my petition at page 30, Lordship. It was moved without the requisite approval of the cabinet under Rule 4.1 of the Government of India Transaction of Business Rules, Lordship. And any decision taken in violation of the rules, of course, Lordship, cannot be sustained. Then secondly, the secondary, sorry. Lordship, this I have stated in para 52 of my petition. This reason is in para 52 of my writ petition at page 3132. Page 3132, para 52. This reason I have given in detail, Lordship.
Yes.
In the writ petition. Then, Lordship, the second reason is that significantly, even while moving the official amendment for replacing Clause 6 by the present Section 6, the Section 6 makes the minister chairman of the search committee, Lordship. In the original bill, it was the cabinet secretary, as usual. Cabinet secretary is generally the chairman of the search committees in all the search committees, Lordship, for various constitutional and administrative posts, high posts. Has been the cabinet secretary. Here, the original bill also, Lordship, provided for the cabinet secretary, but it was moved, and this amendment was moved at the time of the debate on the bill, Lordship, by the minister at the last minute. So even while moving this official amendment for replacing this clause 6, which provided for cabinet secretary by the minister, no explanation was given to justify the change regarding the committee being headed by the minister instead of the cabinet secretary, and for dropping the words having experience and in matters relating to elections. So this change was made surreptitiously at the time of moving the bill. Nor were these changes discussed during the debate, Lordship. This is important because I have gone through the debate on the bill, and this change was not discussed at all, Lordship. I have mentioned all these things which I am submitting, Lordship, in my written submissions.
Yes, yes.
S. Krishnan, which paragraph are you relying on?
Lordship, for this, this is there in para 53, Lordship, of my writ petition.
No.
This is, I'm referring to
The
that.
particular passage from S. Krishnan
this,
you read out
but
is
yes, Lordship.
which paragraph? 51 Supreme Court, which paragraph?
Yeah. 53, Lordship, at page 32. 53, para 53, page 32, Lordship. The submission is there, Lordship, from that.
No,
paragraph.
but how does the paragraph start? What is the starting words?
1 minute. 1 minute, Lordship. I'll just. Lordship, may kindly have my amended petition, because the original petition was subsequently amended twice, and this I'm referring to the amended petition, Lordship. Para I'm mentioning of the amended petition. 52, I'll just read, Lordship. It starts with this. 1 minute. Yes, Lordship. This is at page 31. That a perusal of the aforesaid note dated 6/12/23 in file number such and such, received with the letter dated such and such of the legislative department refers to the herein before, shows that the approval of the cabinet for the change in the composition of the search committee proposed in the original bill was introduced in August 23 was obtained without sorry. That was regarding the first point, Lordship.
Regarding the
Para
first point,
52.
sir, which paragraph of
At page
S.
31.
Krishnan are you relying on? Can you give us the paragraph number and the starting words?
Lordship, Lordship. For the first point, Lordship, para 52 of the amended writ petition, Lordship, at page 31, Lordship.
From the judgment in S. Krishnan, AIR 51, which
Which-
paragraph
which-
of the judgment?
No, the AIR 51, because I don't have the para number of the AIR.
SCR does
but
not have
in the
paragraph numbers.
SCR,
SCR does not have paragraph numbers, so please tell
exactly,
us
Lordship. So-
how does the paragraph start?
Lordship is right. Lordship is right. For the SCR, I have given the page number. The judgment begins at page
Sir, please try to understand.
621.
Please read
The
out
earlier judgment, Krishnan versus the State of Madras.
Can you read out the paragraph in its entirety from the first
Yes, sir.
word? You said that if any law is enacted to defeat
No,
the constitutional provisions, it would
Lord-
amount to a fraud.
Lo-
Where is this particular expression in the judgment? Which particular
sir.
paragraph?
Lordship, I don't have the para number, but it is at page 634 of the judgment in the SCR.
Sir, do you have a copy of judgment before you? Sir, do you have a copy of
34.
judgment before you?
No, Lordship, I don't have copy of the. I got this.
No.
I got this sentence while going through the judgment in the net. While going through the judgment in the net, I got this copy. I mean, this particular sentence, which I thought is applicable to our case. I am giving the page number of the SCR, Lordship, where this sentence is there, 634, Lordship. The judgment is at page 621, and this observation is at page 634, Lordship. Page number I have got, not the paragraph number, because it is not there.
Let's say.
34.
Page 634, Lordship.
1 second.
It was held in that case, Lordship.
But sir, this is saying it was frankly conceded that if Parliament or a state legislature passed legislation in a manner which amounted to a fraud on the Constitution, inasmuch as those enactments were passed with the purpose of defeating the constitutional provisions, then those laws could be attacked on that ground, but not on the ground of their vires. That in the present case, no such argument had been taken or could be taken. And that being so, the contention of Mr. Nambiar was not justified.
Can I give the para number?
There is no paragraph.
No, in SCC, it is reported, it starts in para 34, in SCC, my lord.
That will be an
Already has it.
I'm saying,
Look, there are judgments given by 4 learned judges.
yes, my lord.
So
What
the
my-
lead judgment is by Justice Patanjali Shastri,
Please, your lord.
right? The portion on which Mr. Shukla is relying is by Justice Mahajan,
Yes. Concurring judgment.
concurring view.
And it starts with saying, after a careful consideration of the argument by Mr. Nambiar, I have reached to the conclusion. My lords have got it.
Yes.
If your lordship have SCC, my lord, I
And
can.
we are on that paragraph 34, SCC.
Please.
Yes. But is it law declared? That is what is to be found out. Very strong words, no doubt.
It can be
But
assayed.
whether it is law declared, that has to be shown. Very well. Continue, Mr. Shukla.
Lordship, it was said that it can be sustained. Yes, Lordship. Yes. Yes.
Yes,
Can I
yes, sir,
continue,
proceed.
Lordship?
Please proceed.
Sir, please
Yeah.
continue.
Grateful, Lordship. That was earlier, Lordship. Then I was on this section 6 being liable to be struck down. The first reason I had mentioned that it was moved by the minister without the requisite approval of the cabinet.
Right.
That is in
Well,
para
well.
52 of my writ petition, Lordship. Then I was on the second point that it didn't give any explanation for to justify the change in the committee had to be headed by the minister instead of the cabinet secretary as proposed in the original bill. Lordship, this point is in para 53 of my writ petition at page 32, Lordship. Evidently, the approval of the, on this point, I am quoting this, evidently the approval of the House on the said amendment was obtained and given without any application of mind, contrary to the law laid down in ONGC Limited versus Western Geco International Limited, 2014, 9 SCC 263, para 38. This I have mentioned in para 53 at page 32 of my writ petition. This is the second reason as to why section 6 cannot be sustained.
Yes.
Then, Lordship, the third reason is it is also violative of Article 14, being vague, irrational, and arbitrary for the reasons detailed in paras 54 and 55 of the writ petition. I'm summarizing: by making the minister chairman of the search committee, its political neutrality and fairness has been clearly compromised, and the whole process of having the committee to identify the ablest, bold, and independent persons got. And one point which is not here, Lordship, which I have somehow got omitted in this written arguments, is that it is important, Lordship, that this is not a committee. This is not there in my submissions, but I'll just add it here just to clarify. Lordship, it is not, such committee is not a committee, Lordship, because the other two members of the committee are nominated by the minister himself. So it is a one-man show, Lordship. That is a very important point. It is committee only in name. Under the rules of business, all orders in matters which don't require to be referred to the Prime Minister or cabinet subcommittee, the minister is the final authority. So in this case also, the minister can nominate the other two members of his choice. And that is what has been done in this case. The other two members were nominated by the minister. So virtually, it is a one-man committee, not the search committee. In all other cases, Lordship, in all other for all other offices, the search committee generally consists of the cabinet secretary, the secretary department of personnel, who handles the senior officers matters, and the secretary of the department concerned. So here also we have proposed that the search committee should be the cabinet secretary, secretary of the department of legislative department, which is the concerned department, and the other member, the secretary of the department of personnel, because he would know the biodata of the eligible officers.
Yes.
So that should be the. So it is not committee at all. It is just one-man show, Lordship. That point somehow got omitted here, but it is there in the writ petition, Lordship.
Very well.
Thanks, Lordship. Then, Lordship, I'll now come to section 7.1. relating to the section 7.1. This is
Yes.
this was regarding section 6 relating to subcommittee. Then I come to section 7.1 relating to the selection committee, Lordship, as to why it cannot be sustained. Likewise, the composition of selection committee in section 7.1 is also violative of Article 14 for the following reasons detailed in para 59 of the
Right.
petition. These reasons I have detailed in para 59 at page 37 of my writ petition. And now I'll just briefly summarize these reasons. The first is mere inclusion of the leader of opposition is meaningless as his opinion can be ignored and overruled by the Prime Minister and the Minister, as has been done in this case, defeating the whole purpose of having a selection committee. So here again, it's a one-man show. It's not, it's committee in name only. The decision maker is the Prime Minister. That is the first thing. Then the second point, Lordship, is the present composition by a 9 judges bench in the second judge's case and reiterated by 9 judges and another 9 judges bench in the special reference, wherein it was held, Lordship, and I have quoted from that judgment, wherein both the 9 judges benches, Lordship, they said this, and I quote, attention has to be focused on the purpose. What is the purpose of the committee? The purpose of the committee is to get a person who is acceptable to all political parties or to most political parties, not only to the ruling party, Lordship. Attention has to be focused on purpose. That purpose is missing here, Lordship. It doesn't pay attention to the purpose of the committee, the selection committee which has been provided in the Act. Then to enable better appreciation of significance of the role of each participant. Each participant of the selection committee has a role, and that role has to be appreciated. The present composition does not appreciate that role. I mean, doesn't leave any scope for appreciating the opinion of the leader of opposition, Lordship, because the other two can combine and take a decision and ignore his opinion. So that the role of the third person is zero in this case, Lordship.
Yes.
With the consciousness that each of them has some inherent limitation. That limitation is already inherent in PM and the minister being on the one side. So naturally, that limitation is that they would like to have a man of their choice rather than listen to the third member of the committee. So all these, and it is only collectively that they constitute the selector. That is the 9 judges bench, Lordship. That they collectively constitute the selector. So to say that the 2 members of the selection committee are good enough, they can take whatever decision they want. This sort of decision making is totally against the 9 judges, 2 judgments of the 9 judges bench's, Lordship. That is our second point, Lordship. Then, Lordship, the third point is that it does not remove the grave lacuna in the procedure for appointment of CEC and ECs, for the removal of which the Constitution Bench had intervened, defeating the whole purpose of the well-considered decision. That is another point, Lordship.
Right.
In this respect, Lordship, paras 160.
We will look into it. We will look into it. Come to your point 4.
Or they have already been brought to your Lordship's kind notice. In point 3
Point
is,
four,
Lordship,
point
this is in para 62, which I just mentioned. Point 4, yes, Lordship. Point 4 is, as brought out in paras, 1 minute, Lordship, I have difficulty in reading. As brought out in paras 84 at page, para 84 at page 57, of the writ petition, the selection committee as it is constituted as it is constituted, has an inherent incapacity to select the best person through an objective assessment. The composition of the selection committee has an inherent incapacity to select the best person on an objective basis, Lordship, for the simple reason that the other two members can overrule the third person. So there is no objectivity in the selection. So for these four reasons, Lordship, our submission
No,
is
you
that
have referred
section
to Justice
7.1
Nagaratna.
cannot be
Is there a
sustained.
judgment? Please see written submissions, paragraph, page 3, foot.
Yes, Lordship. Page 3. Yes, Lordship. I'm on page 3 only, Lordship. I have not mentioned the judgment, Lordship, but this point was made in one of the articles. Page 57, 84.
Lord,
With my Lord's
may I make one
permission.
request, my Lord, if it appeals to your Lordships, in this very matter, after the learned AG concludes, Lord, I would also like to assist your Lordships. But today at 2:30 there is some issue, but today the 9-judge bench is also getting over. The amicus is to argue. I would not like to be there after, my Lord, one of my matter is over. Can I be given some date, immediate, whichever date is convenient to your Lordships? Wednesday.
How long will you take?
It depends on the intake from the.
Depends on the intake.
Intake.
I didn't want to put it, I mean, what I mean to convey is, depending on the questions which may come to me.
Okay,
But I'm certainly going to.
We will not ask any questions.
That should
No,
make
it's going to take a little time because as I told you, Lordship, there's something very fundamental concern unless
Next
we
week also.
unfold that, and it will take a little time.
Mr. Sir, if you are there, next week, if Justice Masi is free, we would be sitting together to dispose of our partnered matters. And we will bring back Yes Bank for one reason, which will also give you the opportunity to address us, which we deprived you on the last
grateful.
occasion.
I'm grateful.
But first day, we want your officer to be here because you will be called upon the next day.
My lord.
Why, I will not say.
No, I need, your lordships need not.
If we sit for 3 days, first day, we will bring it back. We will indicate something which your officer must also know. And then the next day we will hear it.
Only for my clarification, your lordship need not, I'm not asking for the reason, my lord.
Right.
But
Because
I-
in this combination, we should not. Because
No,
it is after all
otherwise
with
also-
Justice Mercy. we
Otherwise
have-
also I cannot ask. Why, my question, I appeared for central government, Reserve Bank of India and State Bank of India. My lord, whose office?
Central government.
Central. If somebody conversion would be here. That's all. That was the only purpose of my ask. So, my lord, subject to that, my lord, some date may be given. My lord.
No, we will take it the following day. If we are sitting, we are trying to arrange a combination of Justice Mercy and myself for Tuesday, Wednesday, Thursday. Because we have more than 10 parted matters.
My lord, as per my estimate of the honorable 9 judges bench, it is likely to be over today.
It is likely to be over, but
What
this
is
is
also,
also,
my lord, so indicated. It's not just.
it is likely to be over today. So next week, perhaps you will be. But in that case, this matter has to,
My lord, would your lordship consider, my lord, if it is possible, tomorrow afternoon also, my lord, 2 o'clock, if your lordships can
It's not that.
fix it up.
Mr. Hansari, we have already 60 in
Oh,
the
I'm so sorry.
list and another
And
10
then-
to 12 will be added in the
In the
supplementary.
afternoon, very well.
I mean, I must match the speed of their thought process. I must also have a little time to.
Very well. My lord. Whenever it's
We'll
convenient,
have
of
to
course.
burn our midnight oil tonight. Will not be possible.
I know.
We may see it,
Very well.
but nothing will register in our.
Very well, very well. Whenever, my lord, this side
It's
of
a
the,
very important matter. And
It's an
not-
Important matters,
Very
so, you know,
important.
we
Yes,
must
yes,
have,
much more important.
yes, yes, yes. It's,
There are another
no
many
doubt
cases
about
we
it. No?
have
There
every
we are at item that we are,
let us see, we'll try to
it's an important.
find out, we'll try to find out. उसके बाद तो last week of vacation ना. Accommodate
I'm
everyone.
grateful.
Please,
Obliged. Lord, can I take your lordship's copy?
I mean, having assisted the court in Anup Aranwal, yes, I know how
Right.
the flow of thoughts happened and what concerns the court expressed in the course of hearing. And but then after the judgment came, looking into very important core issue, I tried to flag it, and I'll read my written submissions. For any good reason, if the court were to lay down certain principles, whether or not in the context of declaration of law or otherwise, I'm putting it very wide. And the concern of the court is to ensure that an adequate or a good or a suitable legislation is enacted to deal with the subject in question, which engage the concerns of the court. Then where does it lead us? Before Anup Baranwal, all those instances where 142 were used, guidelines were laid down, there is some lack in the law or inadequacy in the law, or there is no law at all, like Vishaka. So all those are cited to show that the court will be the best suited place to find out what will be the parameters of a good law. So let's take to the next question. If court, for good reason, I'm not saying the court will not never enter into it. If the court were to enter into it, then perhaps we close all possible opportunities for the parliament or the legislature, even a state legislature in a given context, to take a call on their own. And they take a call on their own, then the next step will be, how can you take a call on their own? So how do you therefore enter into a debate on whether the taking a call on their own is good or bad? Then you come back to the judgment and then test it again on the basis of the judgment. So we run somewhere into some kind of a circular process. That's why I said it's an important issue. And I'm not here to advance a proposition saying that forget about free and fair elections and things like that. It's all important for nation. When we can't talk about democracy without free and fair elections. But there are many contexts and circumstances where the free and fair elections have engaged the attention of the court, engaged the attention of the common man, And then if you go back and point about 20 years ago, the kind of booth capturing which used to happen, a different situation exists today. We have moved far away from that. Therefore, if somebody were to say for 75 years, we tolerated an election body, an election commission body, which were hand in glove with some party or the other, government or the other, I would say emphatically no. We don't have that kind of a record about election commissioners. Therefore, we are trying to, like for instance, if there are grey, dense clouds, rain will definitely come down. There's something in Indian logic which says, yes, that's true. Syllogism, your lordship knows. And when like a lemon becomes ripe, it becomes yellow from green, right? It means it has become ripe. But then the logician says, even when some fruits become red, like apples become red, it need not mean the fruit is sweet. It's a different thing altogether. Therefore, the gap between inferences are very important. So we are trying to log in and place this case on the footing that if there is an exclusive executive presence in the appointment of election commissioners, without anything more, there will be a complete lack of independence. You don't need any further argument. You don't have to demonstrate it. So therefore, we are in a very piquant situation. I thought I want to place that with your lordship. Let me proceed to read my written note. Are you giving copies? Please. I'm a little generous with the copies, no problem. Please. For the court. May I read it? These petitions involve several questions concerning the interpretation of the provisions of Article 13, 32, 142, 145, 324, and 327 of the Constitution. On a conjoint reading of these provisions and the law laid down in their regard, and the separation of powers doctrine, which is an integral part of the basic structure of the Constitution, it is submitted that the relief sought for cannot be granted by the Honorable Court. The questions placed before the Honorable Court by petitioners, namely, as to what should be the composition of the Search cum Selection Committee for appointment of election commissioners and the connected procedure thereof are wrong questions. The question can only be whether this Honorable Court can be invited to enter into examining the legality or propriety of what Parliament may or may not do, having regard to the scheme and architecture of the Constitution. The petitioners appeal to the Honorable Court to hold that what the Parliament has done by enacting the Chief Election Commissioner So-and-so Act is in derogation of the Anup Baranwal pronouncement. Consequently, petitioners further appeal to the Honorable Court to enter its view and verdict on the entire subject of appointment of election commissioner and to declare this view or verdict cannot be departed from. Such appeals are neither maintainable nor sustainable. As stated above, the answers to these questions would be matters of fundamental importance towards ensuring separation of powers, institutional amity, and matters of clarity and correction on the scope of the authority of the Honorable Court in dealing with legislative supremacy and its comprehension and understanding of what is relevant to be done in a given context and a given subject. This Honorable Court, therefore, may not be persuaded by entering its verdict as solicited by the petitioner solely on the basis of judgment in Anup Baranwal. The judgment in so-and-so is not an instance of the law declared by the Supreme Court. The various observations made in the course of the judgment with reference to the Constituent Assembly debates and other reports, etc., are only mere judicial collection of statements and reflections. The case did not involve challenge to any provision of any law with reference to Part 3 of the Constitution, vis-a-vis Article 13 of the Constitution. That the court did not declare on the legality of any offending state action. The schemes of Articles 13 and 141 connote that only when an offending state action infringing Part 3 rights of the Constitution come up for consideration, the court will be called upon to declare the law touching upon the state action for the purposes of guidance of the state and securing the rights of citizens. In the absence of any of these features, as stated above, there can be no declaration of law. In the absence of such constitutionally sanctioned declaration of law adjudication, the question of any other organ of the state to feel bound by observations and statements made in a judgment, though persuasive in character, in terms of political or other logic, may not arise. More particularly, the sovereignty of the lawmaking power available to Parliament will not be treated as having been locked into a closet. Without prejudice to the above, it is further submitted that if the appeal to the color of authority of Anup Paranwal Supra is kept aside, the petitioners have not made out a case for finding fault with the 2023 Act. I have to make good that argument, but I'll do it a little later. The arguments relating to Articles 14 and 19 are hypothetical and misconceived. The reliance placed in the following judgments also is misconceived. I'll come to the judgments also again later. Next, paragraph 9. It's equally important that the vacuum theory should be revisited, having regard to the implications of its manifold expansion, leading to constitutional adjudication becoming political or social debates. While it may be welcome and indeed desirable that the adjudicatory process of the Honorable Court in matters concerning social and economic rights and even in civil liberties can be a useful tool in both understanding the content or scope of certain rights and in matters of their enforcement, it is, however, important that the extension of such adjudicatory processes into hugely debatable areas calling for data, analysis, evaluation, social, economic, and political consideration and concerns and the delicate exercise of balancing computing views, etc., need to be carefully examined. On the premise or on the perception of a vacuum, particularly in the context of identifying matters and aspects which may have been left out or not adequately dealt with in any law, or even not satisfactorily acted upon by the executive in the enforcement, this Honorable Court has found it useful to invoke Article 142 as a constitutional tool to remedy injustices and ensure due performance of public functions. However, the exercise under Article 142 or norms or principles enunciated as in aid of due enforcement of law will not be treated as irrevocably binding on a competent legislature, which will always be competent to deal with the subject within the scope of its authority. The line between laying down working law principles for executive compliance and stating matters inviting the attention of the legislature cannot be blurred. Is very, very important. The reading of the judgment in so-and-so as having indirectly tied the hands of the Parliament will be beyond the legitimate domain of Article 142. It is submitted that the endeavor of the petitioners to read Anup Paranwal as a statute or having declared the law is misconceived is well settled. The judgments are not to be read as statutes and more so in the context of Article 142. As stated above, the proposition that the Election Commission as a body, if comes as a product of exclusive executive determination, will in principle cease to be or surrender its independence is not a question that can be answered in the abstract. The question as to whether an authority or a body, if not acting independently or acting under dictation, will always be matters of fact and evidence. It will be too presumptuous for the Honorable Court to imagine that a body so appointed will necessarily be a body without independence. The question of an independent functioning of any constitutional authority will in any ultimate analysis be a question of a given factual context. In the event of any failure of independent functioning, the Constitution provides for sufficient safeguards. Parliament will always be open and alert to examining such evolving phenomena and exercise its social monitoring role through a lawmaking process where it may be needed to legislatively provide to deal with institutional deficiencies. The next, the aforesaid question and propositions necessarily require examination in the light of the settled constitutional limitation governing the exercise of jurisdiction under Article 142 vis-a-vis the declaratory and precedential authority contemplated under Article 141. The propositions elaborated in the detail herein below, namely, A, that the extraordinary equitable jurisdiction in Article 142 is distinct from the declaratory precedential jurisdiction under Article 141. Several judgments talk about it. And that directions issued to do complete justice do not constitute ratio decidendi or binding precedent. B, that the power under Article 142 is supplementary and gap-filling in nature, exercisable only where legislative vacuum exists and not where substantive law occupies the field. C, directions issued under Article 142 are intended solely to fill a legislative vacuum and operate merely as a temporary stopgap arrangement until the competent legislature enacts a law governing a field. Next, that such interim directions cannot thereafter furnish the touchstone for invalidating or testing subsequently enacted legislation whose validity must be tested, if at all, examined exclusively on constitutional parameters under Part 3. I lay emphasis on this. Now, therefore, that the mere conferment of wide discretionary powers upon a high-powered selection committee does not per se violate the doctrine of reasonableness or equality, particularly where Parliament has consciously reposed confidence in high constitutional functionaries to act objectively, fairly, and in the larger public interest. Reference was made, before I reach further, reference was made to arbitrators' appointment, party autonomy, PSUs. I suppose the high constitutional functionaries under the Act are not equated to PSUs appointing arbitrators. That is a very highly misconceived comparison. Now, therefore, go to the very root of the controversy arising in the present proceeding. The aforesaid principles assume particular significance in the context of the petitioner's attempt to treat the judgment in so-and-so as imposing constitutionally binding limitations upon Parliament's legislative competence under Article 324 and 327 of the Constitution. Such a reading would fundamentally blur the constitutional distinction between temporary judicial arrangements framed in exercise of Article 142 to address perceived vacuum and substantive law enacted by Parliament in exercise of the plenary legislative authority. It is respectfully submitted that once the Parliament has occupied the field by enacting the Chief Election Commission so-and-so Act, the validity of the enactment cannot be tested in the anvil of the interim norms or principles indicated in so-and-so, again, but only on constitutionally recognized grounds of judicial review under Part 3 and other applicable constitutional limitations. Equally, the challenge mounted by the petitioners proceeds on an impermissible assumption that the conferment of discretion upon high constitutional authorities in matters of appointment is by itself constitutionally suspect. The moment we accept this proposition, I think many legislation which involve appointment of public officers will become a suspect legislation. Such an approach disregards the settled constitutional position that Parliament is entitled to structure institutional processes and repose decision-making authority in constitutional functionaries holding high public office, whose acts are presumed to be guided by constitutional responsibility, institutional integrity, and public interest, unless demonstrated otherwise on constitutionally sustainable ground. I will add one further on factual narrations. Any contrary approach would effectively elevate judicial directions framed as temporary constitutional arrangements into permanent restrictions upon legislative power, while simultaneously subjecting legislative policy choices and institutional design to standards not contemplated by the Constitution. Such an approach would unsettle the constitutional balance between the judiciary and the legislature and trench upon the doctrine of separation of powers, which forms part of the basic structure of the Constitution. The propositions aforesaid, which are foundational to the adjudication of the present challenge and bear directly upon the constitutional relation between Articles 14, 141, 142, etc., are elaborated in detail in the succeeding submissions here and below. The propositions raised in these petitions, namely, A, that following a pronouncement of the Honorable Court laying down, with or without such authority, certain principles or norms that it may consider relevant on any count whatsoever, and places such norms or principles for due enactment by a competent legislature, the legislature is bound to and must necessarily enact a law strictly in terms of the pronouncement. B, that in such circumstances, the legislature will lack the authority or democratic discretion to legislate differently than propounded by the court. C, that consequently, any legislation in deviation of the pronouncement of the court should be struck down by the court only on the ground of lack of competence of the legislature to disagree with the court. Then D, that any law competently enacted by the legislature should be tested entirely on the antecedent reasoning of the Honorable Court available in the pronouncement, leading to the enactment of the law on the premise that legislature cannot override such a pronouncement. Are questions which arise for consideration for the first time and being fundamental to the very working of the Constitution must be considered by a constitutional bench of such strength as will be determined in accordance with Article 145(3) of the Constitution. I didn't want to come straight away with this proposition, but it was really a troubling thing which I thought that was placed before a lot. It's very important engagement. Very good. It's pertinent to note that the Honorable Court in so-and-so has held as under. In any case, we feel that there is a requirement to provide a preliminary analysis with respect to the interpretation provision. In this context, we need to keep in mind two important phrases occurring in Article 145(3), which are substantial questions of law and interpretation of the Constitution. By reading the aforesaid provision, two conditions can be called out before a reference is made. The court is satisfied that the case involves a substantial question of law, the interpretation of the Constitution, the determination of which is necessary for the disposal of the case. In fact, in that case, the court had a very interesting observation that is, which one?
So what is the bench strength?
Three judges.
Three judges.
Three. Is maybe that paragraph. Okay. So may I read further? Paragraph 21. The questions that thus arise in the above paraphrasing of the subject are as set out below. A, whether the judgment in Anu Baranwal can be read in any manner of speaking as to provide scope for treating it as a declaration of law, irrevocably binding the Parliament from dealing with the subject of appointment to the Election Commission and taking away the scope of its independent consideration of the subject. Whether such a reading would not be in direct opposition to the separation of power dimensions proposed with the Honorable Court. Whether such a reading would also not amount to suggesting such an intent as above said, and the Honorable Court in Anu Baranwal has carefully enunciated certain principles only for the purposes of independent and unhindered consideration by the Parliament. If I say that the Constitution bench intended a hindered consideration by the Parliament, then we land into difficulties. Whether with such independent, unhindered authority available with the Parliament and the 2023 Act has been so enacted, what is the scope for the Honorable Court to test its validity and then what parameters? Whether it is open to the Honorable Court to second guess the intent of Parliament as to its consideration of the judgment in so-and-so, and whether such exercises would not convert the Honorable Court into a second chamber of Parliament. Whether questions that are being raised before the Honorable Court and the propositions canvassed are not in the nature of political debate, preeminently qualifying to be debates within the precincts of Parliament and not to be answered by the Honorable Court. In the event, the Honorable Court considers that the submissions on behalf of the Union of India and the questions raised above deserve to be considered further, the Honorable Court will deem it preferred to refer the matter to a bench of such strength as we determine in the clause 3 of Article 145 of the Constitution. Whether having regard to the well-settled principle, the judgments ought not to be read like statutes, and particularly in view of the submission that norms or principles stated by the Honorable Court by invocation of Article 142 of the Constitution for dealing with legal vacuum, whether the judgment in so-and-so can at all be treated as still legally operative and alive, notwithstanding the enactment of 2023. In other words, in all such circumstances, when Parliament has occupied the field by enacting an appropriate law, which in its wisdom will be relevant, but the pronouncement of the Honorable Court will not be merely a matter of history and cannot be treated as having judicially enforceable authority. I thought a very important question for logical consideration. And in fact, it took me quite a time to understand.
Was it necessary?
Your Lordship.
Was it necessary
Yes.
for a 5-judge constitution bench to write over 300 paragraphs for a 142 order?
I'll answer that.
Can it not be severed?
I'll
Concluding part is 142. But some law has been interpreted by the constitution bench, which includes the constitution, what has to be the structure, what is the
I'll
architecture.
certainly answer that question. I'm bound to answer.
You will have
I'm bound to answer that.
in
question.
course of your argument, touch upon this.
It's not
Because
it's not,
if it had been really 142, the Supreme Court would have said, very well.
I would not. I will.
Although
Not,
law has been laid down for 7 decades, you frame the law as per your wisdom, but in the interregnum, we say that this should be the structure of the commission.
no, that trouble me.
That did the matter.
Yeah.
Why would the Supreme Court, 5 judges,
No, the
spend so much
I would
time
not. I would
and
not.
then write such a
I would not like to.
painstaking, erudite judgment?
I would not like to call it a labor of waste. I would not like to call it. Being Attorney General, I would not like to do that.
So
But
you
I
say
but
that it is only part of history and has no.
in the sense,
legal-
no, I to high wisdom to find out what can be the better law. That's why I understand the debates left it entirely in the constitution scheme and also left it to a future parliament. Otherwise, they could have also said, subject to such law, parliament will make in the following, subject to certain following enumeration. The constitution makers did not
go
tie,
this far.
did not tie the hands of the parliament.
At all, not
It
at
could
all.
not have. It could not have because in many,
have.
it could not have because we have so many provisions in the constitution where subject to law and where parliament always occurs. So if you tie down the NRP, there is no democracy. So parliament has the ultimate authority. Therefore, in the evolution of a democratic functioning, the Constituent Assembly thought in the event there was a necessity to take away the exclusive authority from the president to fill in, to put it in subject to certain procedural framework, parliament will certainly look at it. That being the thought process. Now the court looked into all that history.
It indicated a mechanism
Yes.
rather than enacting one.
No, and that's where that's where
It
I think there
indicated.
is a that's why there is some
mechanism.
issue there. One could have fallen into that. One could have fallen into it. I said even before Anup Baranwal, we discussed what possible alternates could have been there. Whether this particular committee's report or the Law Commission report or just Venkatacharya Commission report. For instance, Venkatacharya did not suggest what the Anup Baranwal suggested. Therefore, so many suggestions before the court. Can I ask this question then? Can council or parties give a menu for a choice before the court and say, please pick up any one of them?
No, not at all.
But such menu was given to the court. I'm only saying whether there will be a further menu exercise before the court is what's a matter of concern. Because all the arguments today have been similarly, please not only look at Anup Baranwal, we give you all other possibilities of looking at it. From South Africa to South America, wherever we can travel. I also looked into how South America has been doing its actual exercise. Last year, they ran into some problems, even without the Legislative Assembly being the ultimate authority in making appointments. So we are not now asking the court to say which model can be weighed in certain parameters should be adopted or not. So we are actually then converting the court into a parliamentary debate. So with great respect to Learned Trend, for the past 2-3 days, this court witnessed a very interesting parliamentary debate. But it's important for us. I'm not downgrading this debate. I'm saying that it's important for us in constitutional courts, such parliamentary debates do take place. It's important for the court also and for the country to understand what are the dimensions of constitutional adjudication. So I'm not downgrading it, but it's important, say, from a different point of view. Now, having said that,
Yes.
can I proceed further?
Yes.
Part 2, legal proposition. It will be some kind of a repetition with that, but please bear with me. The extraordinary equitable jurisdiction under Article 142 is distinct from the declaratory precedential jurisdiction under Article 141. Consequently, directions issued to do complete justice do not constitute ratio decidendi or binding precedent. It submitted that constitutional scheme embodied in so and so draws a clear and deliberate distinction between the law declared by the Honorable Court, which alone possesses binding precedential force, and directions issued in the exercise of the extraordinary equitable jurisdiction 142 for doing complete justice in the peculiar facts of an individual case. While the former constitutes the ratio decidendi binding upon all courts within territory of India, the latter remains inherently fact-specific, equitable, and supplemental in nature, not possessing the features of binding precedent for future cases. The following propositions fortify the submission. The directions issued under Article 142 may not by themselves seen in isolation from any determination of legality of a given law, tested vis-a-vis Article 13 of the Constitution, and may not form part of the declaration of Article 141, nor constitute a binding precedent, not by itself, in the absence of any such determination regarding legality of a given law, constitute a binding precedent. This Honorable Court has consistently recognized Article 141 for to operate in distinct constitutional domain. The former concern the declaration of law, whereas the latter so and so. Then in State of versus Kalyan Singh, this Honorable Court expressly held that every judgment rendered by the Supreme Court contains two distinct components: the law declared under Article 141, which binds courts; B, the exercise of jurisdiction under Article 142 for doing complete justice between the parties before the court. The court thereby, if you also look at the scan of all the 142 directions, are essentially in regard to what complete justice may be between parties to the court. Except where in Vinit Narayan, Vishaka, etc., we have the larger community in the mind of the court. The court thereby held that Article 142 confers an extraordinary equitable jurisdiction, enabling the Honorable Court to relax the rigor of law, mold relief, or exempt parties from the strict application of legal provision in view of the peculiar facts and circumstances of the case. At the same time, the court clarified that the exercise of equitable jurisdiction remained distinct from the declaration of law binding in the so and so. The said principle, next paragraph, was reiterated in Union of India versus Rajiv Bansal. The Honorable Court unequivocally held the directions issued in 142 cannot be regarded as part of the ratio, and they are rendered in the base of peculiar facts and circumstances before or the matter before the court. I stop here for a minute. If this logic is correct, what 5 honorable judges on Anup Baranwal could have done? On the peculiar facts of the case, there's nothing peculiar on the case before the court. It's only a case of saying, declare that there's a vacuum. Please ask Parliament to occupy the vacuum. Till Parliament occupies the vacuum, please yourself occupy the vacuum. Therefore, there are no parties before the court. But still the court went ahead in saying, on the basis of the vacuum theory, now let's look at it, what should be done in public interest, in the interest of an independent election commission. So it essentially, let's say, an appeal to the brooding presence, what they call it, as Holmes calls it, the brooding omnipresence, right? So it's an appeal to the brooding omnipresence of the court and said, look at what should possibly be the composition election body. So when the court went into that understanding, my only next question was, the court could have stopped by declaring that we have so many options before us. Why has Parliament not considered them so far? We leave it open to the Parliament to pick and choose any one of them. But the court did not do that. Or the court could have said, I think, admire, or pick up one among them. I probably appeal to the Parliament to pick any one among them. The court also did not go along those lines. So I was asking myself a question, what is the rationale and the pressing urgency for the court to say, as an interim arrangement, we think of this following proposition. Unless during that period, there was a need to make an appointment. An appointment was probably impending. So in the period before Parliament make a law, when they will make a law, we don't know. Therefore, before they make a law, if an appointment has to be made in the meanwhile, please follow the following principle. I am not able to think beyond that. If an interim arrangement can only mean that. But if you want to elevate the interim arrangement thinking to a final arrangement thought process, then we have a problem. That's how I read Anup Baranwal. Then let me read the next paragraph. The court observed in Union of India versus so-and-so. The directions issued by this court under 142 cannot be so-and-so. They are referring to a few judgments. Little after Kalyan Singh, it's important to notice that Article 142 follows upon 141 of the Constitution, in which it is stated the law declared will be binding on all core territory of India. Thus, every judgment delivered has two components, law declared and then future litigation, causa matter. This court observed that judgment has two components, all that has been repeated. Then after reference to Rafiq Mashi, the court has compartmentalized and differentiated the relief in the operative portion by exercise the powers under 142, the direction so-and-so while molding the relief, that relax the application of law, exempt the case on hand, the rigor of law, peculiar facts and do not comprise the ratio decided and therefore lose its basic premise of making a binding precedent. That's why I called Anup Baranwal matter of history. It loses binding precedent value. This court in the QA has expanded the horizons of 142 by keeping it outside the purview of 141, declaring it a direction the court changes complexion, so and so. Next paragraph. The court expressly observed only the declaration of law was binding for the direction which you kindly skip a couple of the paragraphs. In paragraph 32 and para 33, these are all judgments which have followed the same principle. Para 33 is well settled that a judgment is a precedent for the issue of law which is raised and decided. Ratio decident is so and so. What is binding on all courts is what the Supreme Court says in 141, which is declaration of law and not what it does under Article 142 to do complete justice. Because I was arguing a matter for three honorable judges. We had the Madhya Pradesh Vyapam admission to medical colleges matter. I'll say a few minutes of that. So two honorable judges, and when they found that the admission to medical colleges were indeed on the wrong course, either illegally obtained or whatever it is. The two honorable judges differed on how do we deal with this case. The Chalameshwar thought that these students who spent 4 to 5 years have acquired some knowledge. It's a knowledge which will be useful for the community. Why should it go waste? So he said, I think probably we'll ask all of them to go and serve the military medical service for a certain period, and then completion of 2 or 3 years of service there, they'll come back and obtain their declaration or as recognition as practice of medical practice. The other judge disagreed with that view. The matter went before 3 honorable judges, where I was appearing for some of those petitioners. I said, Article 142, how do you look at it? So I propounded a certain proposition. Article 142 is like an incomplete theorem, because we search for results by using 142. In a given case, that's why cause or matter is very important. A cause means in a given case, between two parties, it may not be an individual issue. It could be a larger issue. Whether diverse could be like in section 76B of the Matrimonial Act. So whether within 6 months, invariably, you should have a mutual divorce. These are matters not only between individual parties, but probably the community at large. It becomes a cause. Or it could be an environmental issue, it becomes a cause. Or a matter means entirely between the parties. Therefore, constitution makers use these words very, very carefully. So Article 142 is that reservoir of power where for doing justice between the parties, whoever they are, state and citizen, or two private parties, what can be a complete justice? So it is not merely, again, therefore, in a given case, if it is tailor-made only for the two parties, to take it beyond the bounds of the determination in that case and to give it a general jurisprudential principle could be problematic. Then in para 35, again, the same different judgment talks about it. Let me come to paragraph 38. A little later, I'll take a lot to some of the judgments. There's going to be some kind of some repetition, but it's important for us. That's why I thought this one case where the 142 dimension probably will have to be dealt with at some great depth. In paragraph 39, in state of Punjab versus Rafiq Mashi, in our view, the Lord laid out in Chandi Prasad Onial no way conflicts with the observations made by this court in the other two cases. In those decisions, directions were issued in exercise of the powers of this court under Article 142, but the subsequent decisions court under Article 136, in laying down the law, had dismissed the petition of the employee. This court, in a number of cases, it battled with tracing the contours of the provisions of so and so India. Distinctively, although the words employed under the two aforesaid provisions speak of the powers of this court, the former vests the plenary jurisdiction Supreme Court in the matter of entertaining and hearing of appeal by granting special leave against any judgment or order made by a court or a tribunal in any cause or matter. the powers are plenary to the extent that they are paramount to the limitation and the specific provision for appeal contained in the Constitution or other laws. Article 142, on the other hand, is a step ahead of the powers envisaged in Article 136. It is the exercise of jurisdiction to pass such enforceable decree or order as is necessary for doing complete justice in any cause or matter. The word complete justice was fraught with uncertainty until Article 142 of the Constitution received its first interpretation in Premchand Garg versus so-and-so, which added a rider to the exercise of wide extraordinary powers by laying down, though the powers are wide, the same is an ancillary power and can be used when not expressly in conflict with the substantive provisions of law. This view was endorsed in a 9-judge bench in Naresh Virajka versus so-and-so, reiterated by 7-judge bench in Antule, and finally settled in Supreme Court Bar Association versus Union of India. Article 136 confers a wide discretionary power on the Supreme Court to interfere in suitable cases is a special jurisdiction described as so-and-so. It's a residuary power, extraordinary amplitude. When it chases injustice, is the sky itself. Then I skipped the Article 130 of the Constitution legislatively intended to be exercised by the highest court of the land. With scrupulous adherence to settled principles, I'll skip that paragraph. The next paragraph, Article 142 of the Constitution is supplementary in nature and cannot supplant the substantive provisions, though they are not limited by the substantive provisions in a statute. It is a power that gives preference to equity over law. It's a justice-oriented approach against the strict rigors of the law. The directions issued to the court can normally be categorized into one, in the nature of molding the relief, and the other are the declaration of law. Declaration contemplates also either speech expressed or necessarily implied by the highest court of the land. This court in Indian Bank, so-and-so, etc., has expounded the principle and extolled the power of Article 142 of the Constitution to new heights by laying down that the directions issued in 142 do not constitute a binding precedent, unlike 141. The directions issued to a proper justice in excess of such power cannot be considered as law laid down. The court has compartmentalized and differentiated the relief in the operative portion of judgment by exercise of powers in 142, the law declared. The directions so-and-so while molding the relief that relax the application of law or exempt the case on hand, these are all repeated, do not compromise the ratio of identity. This court on the QA expands the origins of 142 by keeping it outside of 141. Therefore, in our opinion, the decision of the court based on different scales of 130 and 142 cannot be best weighed on the same grounds of reasoning, and thus in view of the aforesaid discussion, there is no conflict in the views expressed in the first two judgments. Thereby, it is submitted that the Honorable Court has consistently held directions issued in 142 the peculiar facts of a case cannot rely upon the precedent for claiming similar relief in a subsequent proceeding. Then I go to paragraph.
So you have quoted extensively from the 3-judge bench in Rafiq Masih,
Yes.
2014.
Yes.
2014, Justice Dattu, speaking for the bench, held that Shyambabu Verma and other line of cases are 142. Chandi Prasad Unial is 141.
Correct.
When the matter went to the 2-judge bench, 2015, Supreme Court followed the 142.
I know.
Granted,
I know.
not the 140.
I have so many
There is
instances.
no reference to the 3-judge bench.
We have so many instances where the little deviations happen because the court sit in benches of division benches of 2 or 3. So unlike a grand, so we are not talking about what some daredevils in America write about 9 scorpions in a bottle. We are not talking about that at all. So we are talking about the difficulty which arises.
No, just answer this question.
Your Lordship.
Let us assume we accept your proposition that Anup Baranwal is 140. Right? But Anup Baranwal has interpreted the Constitution and laid down what the law is
You may take a lot
about the independence of the Commission. Right? What precludes us from borrowing the language of Anup Baranwal in writing our judgment that this is law?
Well, that's one possible.
Copyright violation.
There's
Is
one
the
possible.
Supreme Court speaking?
Your Lordship.
Is the Supreme Court speaking? We will just simply borrow that language.
Your Lordship can do
You can't
that.
say that we are
Your Lordship can.
passing a 142 order.
Your Lordship can do that, but then that's where I think, not that I am asking the court to desist from exploring this issue. I'm only laying bare the contours of the debate which will necessarily be involved in it. And that question is a very important question. I'll answer that after I read Anup Baranwal.
Yes, yes.
Uh,
We are not going to say anything based on what Anup Baranwal has really laid down with regard to inclusion of the Chief Justice of India. Please remove it from
I'm
your-
not even.
your mind
I'm not even looking at
that
that.
we are on that.
No.
Chief Justice of India's inclusion will make
No, I'm not looking at it
things
at
so
all.
much better that no one else can be considered.
No.
We are not on that at all.
In fact, I don't want to enter into a debate which will be the best method. I think in this matter,
If at all,
yes,
leave it to Parliament.
I'm not entering.
Parliament
Correct.
is enjoined under the Constitution to
Correct.
legislate. We are not to legislate. We are only to interpret the law. And if at all we are with them, we can say that yes, for X, Y, Z reasons, we feel that 14 is violated. Only to this extent, not on the basis of Anup Baranwal.
I know.
On the basis of Anup.
I know. That's why I thought I should
Because-
always place it.
If I can express my mind further, after the Constitution is the fountainhead of all legislation. Which legislation, according to you, has the next importance in the entire list of central legislations? We have thousands of legislation.
Yes.
If one were to ask you,
Yes.
after the Constitution,
Yes.
which legislation has prime of place or pride of place in the entire set of legislations?
Yes.
Which one will you put?
No, then I will have to classify them in the sense that you lost putting a very important question. I'll answer that. If I look at only an independent judiciary, then ultimately, if there is no independent judiciary, then we have, as S.G. Jaisinghani said, women caprice. We are not talking about a women caprice. Of a rule of law is best captured and comprehended with an independent judiciary. That's one aspect of the matter. We are talking about institutions which have been conceived under the Constitution, each one of them occupying their distinct space and spheres. And they get connected in a way so that each and every department of governance, economic, social, political, each one of them, I think, deserve their special importance. So if I had to answer this question only saying this institution, this law is the foremost, perhaps I'd be missing the connection between the democratic governance and our Constitution.
If I say election laws,
I'm coming to that.
am I wrong?
I'm coming to that.
You have just hit the bull.
I'm
You have taken the bull by the horn. You say democracy.
I'm coming to that.
Without democracy, you have nothing.
In fact, the same Constituent Assembly which enacted it.
No, nobody is. Of course, who is saying not? For instance, in Malaysia. Yeah, let's. Sir, I waited.
We are just on the, no, not to.
We are not talking about Malaysia where somebody came from England and drafted their constitution. We are not talking about that. So of course we are. But then I was wondering, why did I say democracy is important? But even in the context of democracy, you may have a free and fair election. But the social, economic and political governance part of it will be more and more, I think, more expansively governed by our institutions of justice. You may have a small problems here in free and fair election. We manage them with a little dent here and there. But if we don't have an independent institution of judiciary, we have fundamental problems. Today, I'll tell you also what's happening in Nepal. Yesterday, I received some very intensive calls from 3 judges. It's unimaginable what's happening. Either they're asked to resign or face impeachment. So, fortunately for our country, none of those things which happen in our neighboring countries have ever invaded our democratic process. Fortunately for these two institutions, the free and fair election and the institution of justice. And the parliament, to a large extent, has been responsible. There have been aberrations, I'm not getting into that question. Therefore, if you have to go further, they're all institutionally connected. And in the course of Anup Baranwal, comparison made with Controller and Auditor General. Oh, it doesn't occupy such an important place as an election commission. Of course, yes. But if the government can manipulate a Controller and Auditor General, what happens to our budgets? And in fact, lots of you know that in many courts all over the world today. And there is an increasing tendency on courts to look at budgeting constraints, financial management and budgets. Therefore, all these are so well integrally connected. So when the courts therefore enter into those fundamental questions as to what should be a policy and what should be a law, not that the court will be invariably kept away from thinking on those lines. There is one set of reasoning among, for instance, in 1990, for the first time, we had a book which published Global Expansion of Judicial Power. First time we began talking about it. Today we have voluminous literature on this subject. And why so? Because whatever we consider about democracy about 50, 60, 70 years ago, the Cold War area and then new communist countries opening into democracy, we have new dimensions of governance which are challenging, which are very, very challenging. Therefore, the role that the court can play as a deliberating mechanism. You deliberate, it's a matter of deliberation between the government and the court. And in that process, whatever deliberations happen will be important considerations and which the parliament or the executive will pick up. They should not be certainly deaf and dumb to all that. So I'm not saying that. So, but what is important is Anup Baranwal, it traced the entire history. It traced the entire history of what is an independent election body, from Constituent Assembly debates to various things which happened during a long period of time. Obviously, to put it very fairly to the court, obviously the court said, is there not something to be done about this matter? Is there a need for a law to be looked into? I thought for a time while arguing the matter before the court, well, there will be need for the law, but there must be a trigger point for the law to be enacted. Something worrying, something too deeply concerning. In fact, I use my submission, in the absence of a trigger point, probably the court will be a little slow in going beyond and saying there's a need for a law. So having said that, Anup Baranwal is what did I say history? It captures the entire narration of several well-minded people, commissions, reports, law commission. And what does it ultimately do? It stamps it gives a stamp of approval on one or more, or the principle that there must be an independent election commission. But the another aspect was, it can't be exclusively in the hands of the executive. Now that takes us to a question, who will determine what is exclusive? What will not be exclusive? To what extent exclusive? So who will take up this question? So different commissions reports said, this will not be exclusive, this will not be exclusive. So different formulas were suggested. Therefore, the courts wisely did not say that I pick up this formula as the only correct formula. And the court also knew that given our democratic separation of powers issue, court said, all right, please, I bring to your attention the importance of looking into this matter. If you think, Parliament think that this is how it can be looked at, I offer you all our reflections on this judgment before you. I will only be very humbly say that the Anup Baranwal is a collection and gathering of the reflections of the court at the highest level, persuaded by certain concerns and the need for an independent election commission. But to put it beyond that, I've been argued before a lot, to say that pick up something from that court. And therefore, if the Parliament has not, as if non-application of mine, things like that, I think that we're reducing Parliament to an executive authority. So it's a very difficult, complex area. And I'm not saying that the court may not have any reflections at all. But to say the reflections will ultimately bind the Parliament in some way or the other, that's where I thought Anup Baranwal, as probably unknowingly or whatever it is, I wouldn't put it like that, I can't read the judge's mind, had gone into that framework. It thought if the Parliament were to look at our reflection seriously, it will take us seriously. And if Anup Baranwal has said all those 4 or 5 to be considered by the Parliament, then Parliament could have voted in favor of any one of them. If Anup Baranwal has not said that, it only picked up an interim arrangement, can we then say Anup Baranwal placed extraordinary importance and emphasis on the only one thing that they wanted to be an interim arrangement? probably I would say no. The entire argument of the petition say that having given that, the best thing Parliament could have done is don't deviate from it. Pick it up. The best solution given by the court. Why do you have any other thinking on the subject? So I'm not able to read Anup Baranwal in that manner. If it can't be read like that, then that's why I thought, and this law, we looked at independent of Anup Baranwal. Again, I find we are caught in a fix. Because the whole thing is part of our judicial history now. That's why it's a judicial history. So independence, exclusive executive presence, etc., have become like thoughts in the political process. So it can be part of a parliamentary debate, part of a social debate. Anybody will ask this question, exclusive executive authority is free, is bad for a free and fair election. But I would probably go further and say, unless this exclusivity of executive presence has always demonstrated and is always likely to demonstrate the lack of a complete independence of an election commission, then one can go forward. But that's going to be a very difficult proposition to establish. It is not like, as I said, something which is a truism. It can't be taken as a truism. So, may I proceed further, Lordship? I was reading at paragraph 40, kindly come to paragraph 42, 43. This Honorable Court noted in Diagram so-and-so. This court noted the fact that in exercise of the powers under 32 or Article 142, guidelines and directions have been issued in large number of cases, and that issue of such guidelines and direction is a well-settled practice which has taken firm roots in our constitutional jurisprudence, and that such exercise was essential to fill the void in the absence of suitable legislation to cover the field. Consequently, the court issued various directions with the following preamble. As pointed out in Vishaka, duty of the executive to fill the vacuum by executive orders, because its field is coterminous with that of the legislature, and where there is inaction with the executive for whatever reason, judiciary must step up in the exercise of its constitutional obligation under the aforesaid provision to provide a solution till such time as the legislature acts to perform its role by enacting proper legislation to cover the field. I stop here for a minute. Then who will give an answer to what is the proper legislation? So somebody will, your Lordship say, yes, Anup Baranwal deserves to be considered by the Parliament. We send the matter back to Parliament. Recently, I was arguing a matter where the court thought will revert the matter for a decision back in regard to some gas and oil field contract extension. And if the matter is to go back to the executive authority, well, you can always reconsider a matter. But Parliament is not an executive authority.
You can't do that.
No, I only wonder, even if Lordship, even if the court were to do that with the highest level of constitutional concern, I'm sorry. I'm sorry.
Go to Anup Baranwal first.
I'll come to that. I'll just and then come back. For instance, in Vishaka, what happened after the Vishaka Guidelines Act came in 2013? The Act did not address, for instance, institutions such as courts. The Supreme Court called for a report from me as to how to make the guidelines of the to be in consonance with the Act. I said the Act is not address this question, then probably the Supreme Court can probably come back on the judicial side and issue further guidelines. Then we had a debate on that. Then ultimately gave a report saying how to make it in consonance with the Act. So today, courts, High Courts, Supreme Court are in fact following some of the discussions we had on this question. Why I'm talking about illustration is that even when an act is passed, we have several concerns which may or may not be adequately addressed by the legislature. So will the court then take it up? That's why I use the word expression in the morning that this court is being treated as an executing court of Anup Baranwal. So therefore, repeatedly, I'm sorry to use that expression, it may or may not be appropriate, but I think somewhere it conveys a certain understanding. I don't want to reduce.
We certainly know that we can't do it. We can't be executing court, but that is why I'm requesting you to read Anup Baranwal.
Yes.
There are references of other judgments also in it. We have to see it as a whole, what it
Your Lordship, please. Yeah, we read Anup Baranwal. This
Judgment का
begins
compilation है ना? Mr. Ansari Adit. Volume?
I'm so sorry, my lord.
Volume one.
Anup Baranwal is in volume?
Volume 3, my lord.
Volume 3.
Three.
Volume 3.
Why? Is the same thing?
93.
Yes, यहाँ पे नहीं है.
Same, no? 93?
Volume उस तरह.
No. 93?
PDF 93. Huh?
Okay, hold on.
PDF 93.
Good.
I feel happy, my lord. My learned friend compared us that we were as if debating in the parliament, my lord. We feel elevated that as at least we can feel that we are member of parliament. My learned friend said so. And I also expect, my lord, we have the same discipline there as we have the discipline here.
We have more discipline. You try to be modest, we have more discipline.
In fact,
That's what I'm saying. I hope we have more same
one of
discipline
the
here.
very passionate arguments made by Sadan was, look here, members are suspended, the bill was introduced, the great has, as if parliament had a malified intention and things like that. Then I looked into it.
Sir, how can we say for a moment
Yes.
that parliament has ulterior purposes or motives?
Yes.
We can't.
Then what I did was,
Constitutional commission
No malice can be attributed.
have mutual respect to the other organ.
no, it was passionately suggested, look here, something is wrong in parliament.
No, not.
Like Hamlet in Denmark, something is wrong in the state of Denmark, and something like that. And then I looked into some data 14, 15, 16, 17 Lok Sabha, any number of instances, either parliament was disrupted. You always have in the rules of business, you notify what business will take place in a particular day, whether disruption or not. On a given day, for instance, there are 10 bills are passed. On this occasion, there are about 6, 7 bills are passed. You will say all the bills are illegally passed. You can't. 122 is a complete answer to it. Article 1, the complete answer to it.
Sir, Parliament may attribute anything to the judiciary, but we know our Lakshman Rekha.
Yes.
We will never do that.
They should also not do that. I am not saying no.
Parliament sometimes does it. Parliament does it.
And your lordships will probably take into the larger judicial fold and try to deal with it and correct it. And that's why Parliament should also say, yes, we are wrong. Wherever they are wrong, they must admit they are wrong. And then in the course of my, I see many litigation exercises where opinions are taken from. I said, don't litigate, because somebody on high said, no, we must continue litigation. So they honor the court's understanding of what should be litigated and what should not be litigated. There is some level of, I think, maturity here inside also. To close our eyes to all that is like painting everybody with the same brush. So let me read this at page 146.
Constitution 42nd Amendment was passed when the Parliament normal term of 5 years was over. The Parliament term was extended, and during that extended period, my lord, when all the persons were behind the bars, the amendment like 42nd Amendment was passed, my lord.
But nobody tested in Article 1.
Mr. Ansaria, you need not say. You all know how.
Fortunately.
What led to ADM Jabalpur?
Yes, ma'am.
Fortunately, there was a 44th Amendment.
Yes, yes. But I'm saying that it is beyond comprehension that you do not have the term, you do not have the people mandate, people elected you for 5 years. But you extended your term yourself and passed an amendment like 42nd Amendment, which completely changed the Constitution. But fortunately, 44th Amendment came and balanced.
I'm not in disagreement with that. I only wish how post-collapse of Soviet Russia and Eastern European nations becoming democratic countries, the kind of phases they have to pass through. Even today, we have Poland and Hungary have problems. So stable, therefore, we are talking about the endurance of a constitution. The endurance of a constitution does not come only from within the institution, it also comes from the people's faith on the constitution. Therefore, if inside there is no effort to instill people's confidence, from outside we will have onslaught. So therefore, we are talking of, whenever all these debates, I think in an ultimate sense, are all about endurance of the constitution. The fabric. Why did Keshavananda spend so much of time on a basic structure theory, which has saved us from a lot of onslaughts on the constitution? So that's why ultimately we're talking about when constitution need to endure, how do the architecture of the constitution will be kept intact as much as possible, except where the little nudging and giving room for certain deliberations, as I said, will have to necessarily take place. Otherwise, it will become too rigid. And like the American Constitution, you can't amend it like this. So we had all that debates all over the world. So may I read at page 146?
Yes.
You lordship will have to put up with me for reading it again all over. Right. A bench of 2 learned judges of the court in so-and-so passed the following order on 23rd of October. So-and-so additional fact is allowed. The matter relates to what the petitioner perceives to be a requirement of having a foolproof and better system of appointment of members of the Election Commission. Having heard the learned counsel for the petitioner and the learned Attorney General for India, we review that the matter may require a close look and interpretation of the provisions of Article 324 of the Constitution of India. The issue has not been debated and answered by this court earlier. Article 145(3) of the Constitution would therefore require the court to refer the matter to a constitution bench. We accordingly refer the constitution arising in the present question arising in the present proceedings to a constitution bench for an authoritative pronouncement. I am only trying to echo the same in my written submissions. Then pose the matter for so-and-so. We may notice the following prayers in the writ petition number 104 of 2015. I just want to remind, I said at that point of time, there was a vacancy in the position of Election Commission. Issue a writ of mandamus.
Why you came straight away to this paragraph?
Para 2.
It's a very lengthy judgment.
No, it's a product. This product, lengthy judgment is a product of 145.3. So that's why I thought. Otherwise, division bench could have said, we need some, there's no law, issue like Vishaka or Vineet Narayan, issued some mandamus and said, we need a law. The court has, that's why constitution bench. So today, I think we are almost in a same scenario, except with certain additions which have been made up. And when Anup Barnwal argued, they dimensioned, namely what's the distinction between 142 and 141, law declared, etc., were not deeply, I think, did not engage the mind of the court. We went on a slightly higher altitude. We need a independent, election commission, and they look at the history. At that altitude, the court went. Rightly so. I'm not finding fault with the court.
Justice Joseph has used 142. Except petition.
What I'm saying is Justice Joseph जो आगे बोल रहे हैं ना दिशा से petition में भी दिया है
तुमने लिखा था petition से
हाँ
In fact, it's para 2.2. I'll place it for lordships in Anup Baranwal. When the petition was filed in 2015, may slowly read it. That the practice of appointing the member to the election commission without making. I'm sorry. No, it's not on record. I'll just send over a copy. It's a Anup Baranwal original writ petition, and which is not part of any of this. With the Lord's permission, I may slowly read it. The practice of appointing the member to the election commission without making a law for a fair, just and transparent process of selection by constituting an independent and neutral collegium selection committee to recommend the name is in violation of Article 14 and 324(2) of the Constitution of India and is invoked continuously since the adoption of the Constitution. Again, the same unconstitutional practice, the petitioner made his petition before the respondent on 3rd of December 2014, but to no avail. And the respondent is going to initiate the process of appointment and the post of the member to the election commission, which will fall vacant due to the retirement of Mr. So-and-so, the chief election commissioner on 15th of January 2015. That's the cause of action for prosecution. That's how it happened. Please, I'll play a copy and give it.
Yes, yes.
Sir, it was a separate note. It was a separate note that we have some
The court.
not.
I think in our written submission. All the rest of points level of
Yes.
Some benches. You can be started.
And your lordship will see after 2018 matter was placed before the constitution bench, we had other petitions who came to be filed in 2021. That is writ petition, paragraph 5. All of them have similarly worded prayers. In paragraph 5, 2021 writ petition, ADR. Then paragraph 6, again a 2022 writ petition filed by Jaya Thakur. All of them insisted that we have a lot of persuasive material in the form of Law Commission reports and Dinesh Goswami report. Please take them on record and issue a mandamus to have an independent system of appointment and so on and so on. Then I'm not troubling lordships with the submissions made because the entire focus was on having regard to the material available before the government and in forms of various reports.
There are 43 also.
Mary, if your lords will permit me to just go back on a few of my submissions made before the court, and they begin from paragraph 13 at page 151. So we have all those debates about the security of tenure, the terms and conditions of appointment which will secure an independent election commission. And now we have crossed all that. In 1991, there was an act which only addressed the question of security of tenure and the duration during the old office. And that also came to be considered in this court. But now that we have crossed all that stage, today this law provides for all those important elements which will assure independence, except what's called the troublesome aspect of having the executive controlling everything, which according to the other side, it is troublesome. Page 152. Before I proceed further, I also have one reflection, if I can share with the court. Both Mr. in Lok Prahari and also in these petitions, I find that that this law is in infringement or not in consonance with Article 324(2). I'm not able to appreciate that as kind of ground of a challenge, because Article 13 says only a law which is widely defined in Article 13. If it is repugnant to provisions of Part 3 of the Constitution, then the court will declare them adjudged to be void. So that takes a repugnancy, they'll be void. And we have somewhere gone around today saying that any other provision of the Constitution can be picked up as saying it is not in consonance with the provision of the Constitution. It may or may not be, need not be necessarily. So you to therefore go beyond Article 13, I think is a little adventurous exercise. So may I read at 13.2 at page 152. So-and-so would point out that the introduction of the collegium or body of person to select the chief election commissioner or the election commissioner would necessitate the court trampling upon the constitutional process of aid and advice of ministers contemplated under Article 74 of the Constitution of India. That is when the president makes the appointment. There cannot be merit in the contention that a tenure of 6 years may inexorably guaranteed. Judicial intervention in matters would be at the expense of causing violent, delicate, so and so and so. And next bit one line. A debatably better model of selection of the commissioner cannot form the foundation of the court to make a foray into the working of the constitutional provision. Then para 13.5. Just about 13.5 and 13.4, we place before the court almost the long history of appointment of election commissioners and who came and remained there for a odd period, 3 years, 4 years, 5 years, and so on and so forth. Just about Placitum F and para 13.4, the contention is it is this system which has been in place for the last more than 7 decades. There is no room for confusion. A long array of chief election commissioners and the election commissioners have been appointed by resorting to the legitimate method and contemplated in Article 324(2). Next paragraph. It's further contended that there exists no identifiable wrong, a trigger point to warrant any judicial interference. I want to place some emphasis on that. Do we have a trigger point now in this case? The only trigger point is that Parliament did not go along the lines as suggested in Anup Baranwal. There is no other trigger point to doubt whether this law has turned out to be a bad law. The potential for abuse, the potential for wrong, the potential for mistakes and errors will not certainly turn a law into an unconstitutional law. So today we have no trigger point at all. And it's pointed out the elections have been held and voting rights ensured millions of eligible voters. 68% polling took place. This year we had a highest margin of voting. Your Lordship knows that. The Election Commission of India, it is entered into various agreements under the auspices of United Nations. I skipped that. Then last line after Placitum H, Election Commission is regulated in the discharge of its function by law in every manner. The matters relating to the appointment of so-and-so have been settled with decision in court in TN session versus Union of India. Then I may go back to some of the submissions here. Kindly, if you'll also kindly permit to come back to paragraph, page 140, 148. We have a one 148. When we fervently appeal to the court and appeal to the court to have its conscience in very important concerns, social or economic, political. For instance, we had the court entered into Manipur issues. So some video was shown. The court said it's a matter of, so it shocks our conscience. But then, as later turned out, as being appearing for the Manipur government, many of this matter, as it later turned out that we have too many things which we do not know at all. And the court, for good reasons, enters into a conscience-keeping exercise, the quintessential and the qui vive. Therefore, what is appealed here is look at what's being stated here at paragraph 8.4. In the middle of that paragraph, it is contended that there has been a sudden change after 2001 in the matter of appointing so-and-so. Successive governments have decided to select increasingly older candidates. This has resulted in casting a shadow on the much-needed independence apart from curtailing their tenure. Inaction on the part of the Election Commission in the face of alarming increase of criminals in public life must guide this court. I'm not able to understand this connection. Of course, the Election Commission acts within the parameters of its law. And today, if you have to say that the Election Commission in the context of PUCL judgment and ADR judgment, they have a right to know. And well, Election Commission has moved forward with that line of thought. Next paragraph. With reference to the article which you adverted to, it is pointed out the Election Commissioners indulged in the alleged misconduct and favoritism. A vigorous appeal is made to the court to listen to the constitutional silence and understand the dire need of the court to step in. In this regard, we are reminded the court has played a proactive role in matters relating to elections and electoral reform. Interference is noteworthy in matters related to so and so, so and so and so. Therefore, we have a long list of interference by the court. Add one more context. So it's contended that no mandamus is sought against the parliament or to implement so and so the following directions are pressed for until a law is made. So this is one of the suggestions put up before the court. Then I was reading my submissions. Now kindly come to can you also kindly come to paragraph?
Just 1 minute.
I'm sorry.
3:30 PM matter will be deferred till next week. Yes. But sir, have you seen the segment Z?
Lordships, which
Independence, a sterling and indispensable activity.
which page?
This is page 245.
245.
You were referring to the submissions. Let us not be too much bothered about what submissions were made by parties. But let us see what the
No,
court has
they
held
constitute the bedrock.
with regard to independence.
Yes.
These paragraphs have perhaps not been placed before us, but these are
Somebody.
245.
Yes.
You placed.
Heading independence as sterling and indispensable. That's
Sorry, I missed to mark it on the last occasion.
there is a heading independence,
Independent.
a
Then-
sterling and indispensable
Yes,
attribute.
Yes.
That's right. It makes a very important reading, but let me have some.
Keep it in mind because
Some,
this is quite.
not caveats at all. I would not disagree with this observation at all. Nobody can disagree. But the problem is, the first question, what is independence? The competence of a man is not to be conflated with fear of independence. A person with excellent has chosen vocation, excellent administrator, honest, quality so and so, transcends the qualities of the professional excellence as also the dictates of honesty. So this can be anything like a good set of maxims for what is independence like, what is curiosity, what is intelligence, what is attributes of a human being, what is morality. They were very important statements. We may no doubt clarify that ordinarily honesty would embrace the quality of courage and conviction, showing the perception of what is right and what is wrong. Then Placitum C. An election commissioner is answerable to the nation, no doubt. The people of the country look forward to if the democracy is always preserved and fostered. Certainly, we may qualify the above observation by stating that true independence is not to be confused with sheer unilateralism. That's a very important statement. This means the election commission must act within the constitutional framework and the laws. It cannot transgress the mandate of the either and still claim to be independent, riding on the horse of independence. It cannot act in unfair manner either. Imagine I go back in point of time to TN Session, who made this body very independent, really fiercely independent. Then we had for about 5 to 6 years, 2 election commissioners appointed, challenges were made. And so in the even case, if suppose TN Session were found not in conformity with these statements of independence, so probably a court would have thrown him out. I'm not very clear about that. Therefore, these are statements made to characterize the attributes of independence when in the midst of all those pressures which may come upon you to function without fear or favor, etc., then what would be required in a human being?
On the perception of the polity as to who the chief election commissioner is, it is not, you'll correct us if we are wrong in our understanding. It is not sufficient that the commission is independent. It must appear to be independent also.
It's certainly. Yes. I'm not saying no. The appearance of being
So
independent will be demonstrated.
If you accept this proposition.
It will be demonstrated. Let me go.
If you accept this proposition, sir,
Well,
then how do you secure the independence?
let me say why I accept it. When I say appear to be independent, it will be demonstrated in everything it does. And is called upon to do.
Appointment.
And is called upon to do.
Right from his appointment.
That's right. No, not from the appointment.
Not
After
right from the
appointment.
appointment process.
I'm saying after appointment. No. Appointment is not a matter which will test the qualities of the person. It's known only to the person who select him. He cannot certify himself. Before taking over the mantle, I do not know what exactly will be my independence I will be called upon to exercise once I become an election commissioner. It's only when I wear the shoes I know where it will pinch. Therefore, to test it before somebody is appointed. After appointment, well, yes, justice must seem to be done. The same yardstick will apply to the election commissioner. Therefore, if paragraphs 249 to 251
must have the same confidence in the body when the third member is a neutral person. That the level of confidence must be to that degree. That if there had been a third person, absolutely neutral, the election commissioner who is now being appointed must be selected by a body of at least one absolutely neutral person. We don't proceed further to say that how he will be appointed, Prime Minister cannot appoint. We are not saying that. But should be by somebody who is a neutral person. He should select. Why should it be a minister from the cabinet? There are, let us assume, the ruling party has 300 MPs. Not 300 MPs become ministers. The Prime Minister, the discretion lies with him. He will select 25 of his best. Now you again micromanage it and bring one from the 25. Why?
Yes. No, the question is whether the very act of doing that, could have been done only if beyond the Prime Minister, somebody else is there who is part of a cabinet. If that very act could have been done only, the answer would be yes. But the answer is not, it doesn't stop there.
No, why do you then include the leader of the opposition? He's ornamental. It will always be 2:1.
That may be.
Why do you put up this show of independence in the body?
So we can always. Therefore,
be 2:1. Do you think that the member of the cabinet will go against the Prime Minister?
Yes. May not be.
So
may not be.
When you are
may not be.
I will framing a law, sir.
Can I?
This 300 paragraphs were not written only for the purpose of 142.
No, I'm not saying that.
Sought to give some.
I don't, please. I'm not saying that. These paragraphs are set out only to underline the thought process of the court as to if it's important to have an independent election commission, what will be the attributes of that independence? It's only to kind of enumerate and say down what are those attributes, so that somebody who reads them understand what are those attributes in practice. How will you practice these attributes? Beyond that, will they serve any purpose? It's for the people's understanding. Therefore, very often lordships write in judgments, make observation which you go to substantiate the reasoning and the thought process of the court. They add a certain weight in the reasoning to the reasoning part of the court. It's in that context all these have come.
May I request you to read the first sentence of 251?
251.
I think 250 is also very important, Madam.
250 is there. Just, we are short of time today, so we are just cutting it short. We are expressing our mind so that attorney can address us.
I'll certainly.
251.
Let me say, if you lot, today I'm in part 1 address. I'll certainly come back.
You were in part 1, yes, we understand. But you would also be putting one question to the petitioner side.
Yes.
Before we close for the day.
Yes, Your Lord.
But just see 251.
I'll read that here. Upholding the constitutional values, which are in fact a part of the basic structure, and which includes democracy, the rule of law, the right to equality, secularism, and the purity of election, otherwise would indeed proclaim the presence of independence.
Right. Yeah.
Independence must
Two words are very important: democracy and the purity of elections.
Correct.
Right. So therefore, the court is giving importance to these values as part of the basic structure of our constitution. So you will have to establish that, yes, by framing the law in the manner it has been framed, it does not defeat the constitutional provisions. The statute law does not seek to get over the constitutional law.
Yes.
This part you will have to explain to us.
I'll do that, but what a thought goes to my mind on my feet. If you look at the early part of a democracy, when we were an evolving nation, we are confronted with so many questions. So we started beginning with land reforms. But then we didn't have enough institutions which could have addressed all those social, economic, and political concerns. So as we began into addressing the concerns of scheduled castes, scheduled tribes, and other deeper sections of the community, we began looking into the relevance and importance of institutions. Today, we have several such institutions which occupy the field of doing justice within the governance of the architecture of the constitution. So therefore, we are talking of enhancing an institutional structure and its foundation. We grow through experience. So therefore, I said if in the 60, 75 years, if there are election commissioners who only by reason of president appointing through a minister's aid and advice process, if they have failed and they have miserably failed, or not able to advance rule of law and democracy in free and fair election, we would have learned an important lesson. But we don't have that kind of a very unfortunate, devastating, or a sad experience. We did not have certainly free and fair election in certain parts of our country, but that could not be attributed to the election commission. So it's very easy to say, put everything on the doorstep of the election commission. But we have free and fair elections in different parts of the country. So, and who is responsible for them? So somebody, I'll stop there and read 251 next line. Not unnaturally, uncompromising fearlessness will mark an independent person from those who put all they hold dear before their karma. Very important statement, no doubt about that. But what I'm saying is this looks like a textbook of reading for somebody before they take oath. An election commissioner is called upon to read this paragraph. I abide not only by the oath I take, I also look at paragraphs 249 and 251. It will be a valuable addition to their placing things before their karma. I understand that. But that I'm not also saying 142. I'm not saying that at all. But what I'm saying is all was necessary for the court to lay a huge canvas for the court to ultimately come to a conclusion. Because as I said, there was no trigger point, but the court went into it. Even then the court, in order, having gone into it, the court has to reach somewhere. Your Lordship knows in the judicial exercise. In an ordinary case, you have to reach somewhere. How do you reach somewhere? The reasoning part always troubles the minds of the judges. I mean, reaching somewhere reasonably, fairly, doing justice, so on and so forth. It's a very difficult exercise judges undertake. Therefore, the court in this case, I thought, undertook that exercise of saying, I must reach somewhere. So what is that reaching somewhere? Ultimately, is that interim arrangement and emphasizing the importance of an independent election commission. But the question thereafter is, what will be attributes of a body or a process or a procedure which will ensure every aspect or every dimension of independence? What are those aspects and dimensions of independence in the process of functioning of the election body? If you look at all of that, I think with all some criticism that can be laid at the door of section 6 or 7, I'll answer them later. I'm not able to persuade myself to say that the current function of the election commission, either under the symbols order or any other provisions of the act, will be seriously compromised by reason of this act. It is just absolutely hypothetical. So if that is not so, then where will the court go further? So that's why what troubled me is not to say that your Lordship will not have any debate on this question. But the end of the debate, where will it lead us, is what is in fact a...
What troubles us prima facie is, why is there an executive veto? After all these precedents, was the parliament not aware of the precedents? After all, we are interpreting the law.
To attribute...
After all, parliament has the power to frame the laws. But the Supreme Court is the final arbiter. It will have the power to interpret the laws, whether you like it or not, whether your law is struck down or not. Constitution has
certainly
got this power.
Without any doubt.
Right.
No, if your Lordship to ask me a question.
I'm just wondering, for a CBI director, Chief Justice is there, CBI director, for maintenance of law and order. Or you can stretch it to rule of laws, but not for maintaining democracy, not for ensuring a pure election. We don't say that CGI should be there.
No, I'm not even on that point.
We are not on that.
Yes, sir.
Why shouldn't there be an independent?
No, my question therefore is
why should it be the third one?
What would
the ministry?
No, your Lordship knows in the context of looking at parliament.
Today, let us be very clear. Today, Prime Minister takes one, LOP takes another one.
And there is disagreement.
There is a disagreement between the two. The third member will go towards the LOP.
May not be. May not be in all practicalities. I don't need to second guess all that. So therefore, the secretaries,
The executive who
no, you lost that.
who is controlling everything.
Therefore, what is the secretary? The secretaries will have to find when none of these things will happen.
Secretary is Parliament has to apply its mind.
No, that's right. Even if Parliament applies,
And let there be a proper debate.
I see.
Hear the other side
No.
and then decide.
Even you will
If there is agreement, well and good. Otherwise, you vote.
even after Parliament,
Solution. We are not going to provide you a solution.
even after
We are only
Parliament,
to test whether the law is good on the anvil of Article 14 or not. This is our limited job. Going to give alternatives that this is a better option, that is a better. That's not our job.
even after I understand that. Even after Parliament would have applied his mind, and the Parliament will have to ask all those questions: which is a better option? Which is the best way of ensuring that there will be no infiltration by any process whatsoever on the independence of the election body? The Parliament will have to apply. Therefore, you have so many models. The only way Parliament can debate, only way an executive can take a decision on, how many models do you have? So which model will best suit our country's needs? The Parliament can have a choice. So once the choice is made, there can be problems, there can be deficiencies in the choice. Because Parliament cannot say like in a laboratory, do we have a futuristic vision where everything can be visualized and tested on that basis? Perhaps not. For your Lordship's questions are important, but to say, why would not Parliament think on those lines? So the ultimate answer would be with several models before it. All the arguments before Anup Baranwal, several models before it. If the Parliament say that this is the model I would like to go along with.
Mr. Francis, Mr. Prasad,
Yeah,
all of you,
Please, Your Lordships.
Mr. Gopal.
In his written synopsis, Bernard et al. Has certainly raised a very important issue. I'll read it.
Yes.
The propositions raised in these petitions, namely, that any law competently enacted by the legislature should be tested entirely on the antecedents reasonings of this court available in the pronouncement leading to the enactment of law on the premise that legislature cannot override such a pronouncement are questions which arise for consideration for the first time, being fundamental to very working of the Constitution, must be considered by a Constitution bench of such strength as it may be determined in accordance with Article 145(3) of the Constitution.
Okay.
There's no doubt about it that it's a very, very important Constitution. There cannot be any doubt about it.
You've
So-
had, and also in view of para 2 of Anup Baranwal.
Yes, madam.
In my respectful submission, my lord, I pointed out.
Show me para two, show me para two.
Actually, this issue is covered by 5 constitution bench judgments, not merely Anup Baranwal, but also the 2 Scora and that NJAC, and thereafter, my lord, the tribunal's appointment as well as arbitration. So 5 constitution bench judgments, all of them unanimously say the same thing, that where you have a judicial or a quasi-judicial body, you cannot have the appointments being controlled by somebody who is a party, who is potentially a party to the dispute. So therefore, Election Commission being a quasi-judicial body and the ruling party being a party to the various disputes which go before the Election Commission, therefore, the ruling party cannot dominate the selection of the Election Commission. That's the proposition. In my respectful submission, my lord, this has been settled. This proposition has been settled by these 5 judgments. And therefore, it does not need to go again to a constitution.
All those judgments are prior to Anup Baranwal's case.
No,
My lord,
no, in fact,
Anup Barnwal, my lord, if I can, I'm so sorry.
one,
if
one,
I-
one
All those cases are prior to Anup Barnwal.
Madras Bar Association is post Anup Barnwal.
One,
Yeah.
but all other are prior to Barnwal.
Yes.
all
And
other-
in Barnwal, in spite of all those prior judgments, the matter was referred to a constitution bench.
No, true. But once the constitution bench settles the issue, once the constitution bench settles the issue, of course, my lord, it's always possible for the court to refer it to a constitution bench. All the time
Yes, we
saying
want
is,
to bring the controversy
After all,
to an end.
Mr. Bhushan, you would
once
be
and for all.
appreciating this,
yes,
that if we go by the terms of 145(3),
Yes.
yes.
is substantial question of law in relation to interpretation of the constitution. This is the first requirement,
Correct.
and the answer must be necessary for the purpose of disposal of the issue which is coming before the.
Correct. So if I can just respond for a
I-
minute, when we
decided
just one-
earlier.
1 minute. When we argued Anup Paranwal, the reason why this got referred,
Just here,
yes,
Anup Baranwal was decided.
yes,
Mr. Bhushan is trying to impress upon us that there are 5 CB judgments. None of the judgments are testing a law under 324.
so let me just clarify. Let me just clarify.
I'm
Just
not right in this,
No,
Mr. Bhushan.
so
Actually,
just
All these constitution bench judgments may
Correct.
have been there. But in any of these benches, the law under 324 was not tested.
Law-
This is for the first time.
law was there.
May I say
in
this?
Punjab.
No.
Just one.
No, I just wanted to complete what I was saying. Let me just clarify something. The question which was referred in Anup Paranwal was Article 324, is there a vacuum? That required an interpretation of Article 324 and led to a substantial question which had not been raised in 70 years, whether the appointment scheme had to be provided by the constitution, had to be provided by a statute, could it be implied? Those were the substantial questions. Those substantial questions have been answered today. There is no substantial question regarding 324 that survives. The question that survives is that once there's a constitutional interpretation given by the Supreme Court of India, whether in 2, 3, 5, 7, whatever, can Parliament make a law without removing the basis of that constitution bench judgment? That is the question. That question, Mr. Bhushan is right, not 5. It's been answered by at least 25 judgments. We have a full list here. So it doesn't matter which particular article it's relatable to, whether it's relatable to 324, whether it's relatable to 334A or 334B, 164A, 164B, because the general scheme is that when a constitutional interpretation comes and you make a law to try and defeat it, what this court can do in any combination is test whether the basis has been removed. That doesn't require 5 judges. And also, let me just draw your lordship's attention. When Part 9B of the Constitution came to be challenged, cooperative societies, when it came to be challenged, the constitutional amendment was under challenge. There was an argument raised that, look, this is a constitutional amendment challenge. Obviously, it goes to the very root of the matter. It requires interpretation. Please send it to 5. It was decided finally by 2 judges of this bench, of this court, in Union of India versus Rajendra Shah, and you struck down because it did not comply with Article 368(2) proviso. 2 judges decided that. So it is not, and this is, I'm sorry to use this expression, but this is not the first time this has happened when Mr. Bhushan, all of us have been arguing matters. The minute the state comes with a law, which is ex facie bad and wrong, their first response throughout has been referred to larger bench.
I'm sorry.
First response, not the first time.
Not at all. Not at all.
Every single time, there have been 12 judgments in the last 5 years where their first argument
So sorry.
is this.
Certainly not.
And this cannot be a bogey argument, because what I want to ask myself is,
You don't
what is that question of law of interpretation of the Constitution that, according to the Attorney General, has suddenly arisen in this case for the first time? What is that question? Let's know what that question is.
I want to.
G is not that question. What is this question which is unique, which has not been answered before?
My lord,
Please read my
one thing more I want to add, my lord.
You may have your
Counter has been,
disagreements.
just a minute.
You may have your disagreements. Please
count-
read my question.
Counter has been filed yesterday, my lord. Even in the counter, there is no whisper that it requires 145(3) reference.
So there's an
Even in the counter, my lord, counter affidavit filed on oath by the government of India does not challenge it. My lord, it is.
Yes, sir.
No, he has, no, my lord, in the written submissions he has given. What is in the written submissions, my lord? What we say in the pleadings. Now, in the counter affidavit filed yesterday, as late as yesterday, they could have said, this is my first preliminary objection. They don't file a counter for 3 years. These are the writ petitions of 2022, my lord.
24.
24. They don't file a counter. Despite the last opportunity, today objections was here. We're not saying that your lordship may not take the counter on record. For my lord, 2.5 years, they don't raise this issue that 145.3 requires a reference. Even in the counter filed yesterday, when, my lord, it is, my lord, and what your lordship has said, when questions are not decided, 145.3 applies. These questions have been decided. We are saying the question of interpretation of 324(2) has been decided by the Constitution bench, and we are only arguing whether the law which is made meet the test of Article 14, meet the test, my lord, which interpretation of 324, whether it meet the test of free and fair election machinery, whether it meets free from executive. That is the questions which you are raising. These are all answered by your lordship.
One aspect, Mr. Bhushan will allow me. Because the question of 145(3) will only arise if your lordships first come to the conclusion that the requirement of an independent appointment process for somebody like CEC is not an existing requirement in our constitution.
Please come to 145.
I'm sorry, you are not getting the correct
Please
point.
come to
Can I make
145.
a very short supplement?
Just 1 minute, Mr. Rai.
Yes.
145(3).
Yes, my lords. I'll
Mr.
read it.
Parasat, the point that you are raising,
Yes, my lord.
where is it in 145(3)?
Well, the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under Article 143 shall be 5. So the requirement is substantial question of law as to the interpretation of this constitution.
So,
1 minute, proviso.
I'll read the proviso as well. Provided that where the court hearing an appeal
we are not
under
hearing any appeal. These are all writ petitions.
Yes.
So
Yes.
proviso doesn't apply. Where do you get 2? You get 2 from the Supreme Court rules.
yes, 2 as in, my lord, I didn't get
Two
that.
judges.
2 judges.
Combination of 2.
Combination of 2, I see. Okay.
So,
Yes.
because, you know, when the constitution was initially framed and these provisions were there, the burden of work was not such.
Correct.
Now, with the passage of time, it has been found necessary for convenience
Yes.
that we should sit in
That's right.
combinations of 2, 3, 5, 7.
Even 1 minute.